Yes.
SLP number 303403
Yes.
It could be a different matter. It was tagged on. It should be not SLP number 7964 of
7964
of 2016. That's the main matter for which we are doing. This was mistakenly tagged on your file.
What is this about?
It's against the validity of the law. It was amended, MMRDA.
Right, it's pending, right?
That's pending.
All right. Mr. K. Panindra, Senior Counsel for the petitioner. Mr. S.S. Mehndra, Learned Additional Government Advocate for Respondents 2 and 3. Learned Counsel for the parties jointly submit that the issue involved in this petition is pending adjudication in SLP number 7964 part 2016. In view of aforesaid submission, hearing of the petition is deferred. Signed liberty is granted to Learned Counsel for the mention the matter as and when aforesaid SLP is decided. All right, so we have only recorded your thing. Same order, right? 1 to 5. 1 to 5. 1 to 6. Same order.
I am for the appellant. For the process fee, I am paying today, my lord. I am paying the process fee with correct address.
Counsel for the appellant undertakes to pay process fee with correct and complete address to respond number 11 during the course of the day. What about respond number 3, Mr.?
My lord, I will take steps, my lord, in a week, my lord.
Learned Counsel for the appellant is granted a week's time to enable him to take steps for substitution of LRs of deceased respondent number 3.
Please.
What? RSA? Which RSA? Learned Counsel for the party jointly submit that regular second appeal is pending before the Dharwad bench of this court. The aforesaid submission is placed on record. Hearing of the petition is deferred. Yes.
Number 9.
This regular second appeal pertaining to subject matter of this petition is pending at this. Yes.
Number 9. The Sagar Baby,
What status of Supreme Court? What is, yes, Mr. Howard? Password, let him come. Yes.
Number 10.
Yes. All right, so you are satisfied, right? Yes. Mark the presence. Very rarely, Mr. Patil. Otherwise, everybody complains, right? So, a lighter weight. Yes, Mr. Puttige Ramesh Larin, Counsel for Puttige Ramesh Larin, Senior Counsel for the petitioner. You are appealing for Learned Additional Government Advocate for Respondents number Respondent number 2. In this petition, the petitioner inter alia has prayed for the following relief. Quote relief number 1. It is fairly stated by learned counsel for the petitioner that the issue involved in this petition is squarely covered by a decision of the Supreme Court in so and so versus so and so. 2000 Gajendra Sharma versus Union of India and another. 2021 1 SSC 210. Full stop. In the aforesaid decision, in the aforesaid petition has been aforesaid pre-petition has been disposed of in the following terms by the Supreme Court. Quote para 15. Right, in view of aforesaid decision, the petition is disposed of.
But never,
What are you?
We have applied for wildlife clearance, good and as well as forest clearance. Similarly, for the environment clearance, we already applied. Now, subsequently, you know, the natural green tribunal giving the same land, held that these are not forest land, no clearances are required. Nevertheless, we applied for forest clearance. Now, what is happening? While this matter is pending, the petitioner takes up an application for amendment. Now he says that you should also take environment clearance because we already taken. Now, once the matter comes in the realm of the Environment Protection Act, you want to know it's a scheduled act under the NGT Act. So these are matters which ideally should have gone to the NGT because the Wildlife Act is not covered under the schedule to the NGT Act. So your lordship will rightly seized on the matter. Now, my problem is not this is a drinking and irrigation project. We have spent more than 100 crores on this particular package. Now, because of this order board and also the big petition board, we are not able to proceed with the matter. The contractor's liability is a rising load. We can't proceed.
You have been awarded a contract.
No, we have a government agency. We have awarded these packages.
Oh.
Now, this petition, because of this petition, we can't proceed with the matter. So, I moved out an application for me.
Wait.
Take up this matter, let it be listed next week, watching the year this matter. Because otherwise, we are nowhere.
Yes. Wildlife clearance they have taken, right? What happened? But you said it. Yeah, 1 minute.
The agencies are not proceeding. They are saying the matter before your lordship. They don't want to touch it. So, I was also pointing out the wildlife issue was also considered by the NGP.
Matter is pending before which authority?
For the wildlife clearance body of court. Yes. And I was also pointing out the wildlife.
Yeah, 1 minute. Don't be impatient. That shows that it's not in public interest, something else. Please don't be impatient. We are just trying to understand. It is for office objections. We have not read it. So therefore, we are trying to get it from senior counsel. What is the point? We will hear you. It can't be, no order can be passed until unless you have heard. Even though you don't have a right of audience. If this is a public interest litigation, we have taken cognizance. You can't claim that I will argue. This is not an adversarial litigation, right?
The NGP also considered the wildlife aspect and decided on the issue. The matter was taken in appeal to the Supreme Court.
Where is that NGT thing? What has happened? What has the NGT held?
Yes, NGP judgment was taken in appeal to the Supreme Court after the matter.
What has the NGT held? Which order?
What the NGP says, these are carbon lands which are essentially grazing lands of certain indigenous varieties of cattle. And therefore, these are not forest land, these are not categorized as forest land. So that was a matter where several projects were approved by the government on this carbon land.
Where do we get that order?
So that order is part of the original page. So this will be replied by him. Along with the original petition prior to the amendment. So the order is
Yes.
that page 46.
Ah, yes, 46.
This is the order.
Which paragraph?
That is what Para you can also see. Para,
What is this land bearing number? Give us the particulars, then we
yes, that is
where it has.
if you also see page 77, 78.
Huh? What is this land? Particulars of this land? Ah, no, but land must be some description.
These are this is a Chitraduga district, and these are categorized as Amrit Kavan land. Amrit Kavan lands are grazing lands.
Ah.
So the question was whether these grazing lands are required to be regulated under the Forest Regulation Act and forest clearances are required or not. Now, the tribunal will decide this issue.
So, in respect of this very land or a similar,
characteristics of the same land.
this land in Chitradurga district.
This particular land in this particular petition is part of Tumkur and other district.
No, fine. I mean, the NGT was dealing with this very land. No,
Not this very land,
ah,
but the similar category.
similar category of land. All.
Yes.
So, which para?
177 and
Page,
also-
just page 170.
Yes. So, issue number 2 is the so that is the particular dealing is the species of lands. That was answered to that page 180, 180 almost will be answered about it. So the conclusion we are wanting to find at para 197 at page 277.
Para 127.
Yes.
Ah, yes.
Let's just read it.
Please.
Immediately the entire value of voluntary by the people who are mindful to later from that. The thought to make it also the same as the declare and have it too. Second to one is in the area next area that we make of that as related about whether all the police are established they should certainly provide employment opportunities in which you know their economic opportunity petition and category. The FFPS category point out that the location certain organizations like the property line and so the ground has to use the category. The exposure indicated in the example of opportunity for good answer it goes downward, I will see that, and then you want to go to page 285. This is the operating direction board. Finally, when the court says that these are not like to analysis, and point like this, point of this, finding that this is not correct. It needs to be found. Actually, but if you watch it, come to page 180, I'm showing you. 180. Below the page.
Yes.
According to the report, the annual activity and very size. What is the question?
Yes.
According to the annual activity, what is the measuring scientific position of students makers of 100 model carbon and 62 locations in 6 districts of the total. To note the details of the districts are given. In the year 1980, the carbon lands were reduced to 64,000 acres in 1990, further 3,031 acres. The practice of raising the other carbon field of cattle owned by the supplement kingdom of continued by the government was appointed as the legislature out of 59 regions for modern work from the power line. For the remaining 22 regions, government were appointed. Even in villages that were appointed, the enforcement is according to indicating ineffective water management and monitoring. The history of 100 power line was parallel to the history of 100 carbon. In order to maintain 100 power feet, the department was but is the department of the micro after the administration. It was transferred to the commissioner of the thereafter in the year 1980, department of public director of agriculture. The department of rural qualified. Under the work of the secretary to the agriculture department and removal of 20 hectare site. The declaration of the agreed of federal started in 1945. It could be attributed to improper management and non-execution of order. As a result of
No, it's not. Read that particular finding. Where is it?
Yes. Please see your page 17, page 239. Sorry, page 237. Yeah, the pertinent point of the rule indicates unless one power is accurate grading land for only the other body that is used by the government. Had it been forest as created by the employee, there would be no need for employee or custody for grading that is cannot be made. The definition only indicates that unless one power has a construction land to exclude this land, the terms are as forest. Under one power lands were never notified as forest land under the Karnataka Forest Act. The concession put forth by the applicant that rule particularly of foreign things and that is for another power land are concerned, the said rules governing the management of the district forest to reply copy to the powers and hence they are distinct forests cannot be distinct forests cannot be complements. Since the very implication of the rule is that other power lands are not district forests. Hence it is stated that this will governing the management of district forests reply from the power. The Karnataka Forest Act defines district forests in section 2, which reads as follows. I skip the definition clause. Thus, the Karnataka Forest Act has specifically excluded the land which are assigned for free grazing ground or any other purpose or communal purpose from district forest land. In order to substantiate the contention, both sides were relying on the decisions of local efforts in reporting about. The applicants relied on paragraph 4 of the judgment right stated as follows. The Forest Conservation Act was enacted to check whether the tree foresting continually imbalance and therefore the provision therein for the conservation of forests and matters selected therein must apply to all forest districts of the nation of Push. The following components relied on the following part of the releasing judgment. The word forest will be understood as defined dictionary meaning, restricting cover all statutory within their forest, whether designated as reserve, protected or otherwise from section 2 Act for Forest Conservation Act. The term forest land appearing in section 2 will not only include forest in understood in the dictionary sense, but also any area recorded as forest in the government record, irrespective of the ownership. This is how it can be understood for section 2 of the Act. The provisions enacted in the Forest Conservation Act for pertaining to forest and matters related therein must apply clearly to all forests understood irrespective of the ownership of the classified and classification thereof. There cannot be any clause that the Forest Conservation Act will be enacted only to stop further enforcement allowed. It could result in the economic imbalance and this provision of the Act for the conservation of forest has to be applied irrespective of the classification or ownership of the land. But the Honorable Apex Court in the very same judgment has clearly indicated that the word forest must be understood according to the dictionary meaning. The description covers all statutory forests, whether designated as reserve, protected or otherwise form which will be by the Forest Conservation Act. The term forest include and 174.
All right. Finding. So it has been upheld. Where is that?
So that you are also doing this statutory appeal under section 82. We are very comfortable about this because and carefully on record. In our considered opinion, we do not see anything in the doesn't.
So is there any interim order in this petition?
On 13th of October 2020, your lordships have actually, it's not an interim order, but your lordship will see 13th October 2018. What absolute order, your lordship has given me liberty to come back. Because the last 2 months, we make it clear, your lordship see that. We make it clear that even during the pendency of the petition, such clearances are granted, the action of allotment therein shall not be without taking leave of the court. Let the petition is not reduced, subject for here. That's the only connection that you want.
No.
Unfortunately, the authorities are saying that since the matter we can't.
Where is it? You have applied before the wildlife board.
Yes, and that is recorded in the order. If you watch it, please.
Seeking clearance for what project? Irrigation project.
It's an irrigation from drinking water project.
Irrigation. Where did you apply?
So that is what that is recorded. I just. But if you want to read the computer down to 21. 21 months, yes. Well, I think it is better informed than you know.
21, 10, 20. You also have the application. 21. 10, 20.
So that is based on record as well.
So your application is pending. Yes. No, you tell us. I mean, are you whether who is the petitioner? Activist. They have filed several. They means petitioner, one or several. Two petitioners. So they don't want that irrigation and drinking water project should be, people should get water, right? No, but in any case, if we say so, if you are treating it to be an adversarial litigation, then also there is an order dated 13/10/2020 against you, if we may say so, that they have been permitted to go ahead with the clearances, right? So we will say, Mr. Madam, you process his application. This project is in public interest. We understand petitioner's concern that it should be done in accordance with law. We will see to it that it is done in accordance with law. That is the scope of this petition. Nothing beyond that. You can't be against this project. Only thing is you want a clearance from the wildlife board, right? No, for the present, Mr. We will hear it at length sometime because this order is 13/10/2020. Just a minute. Listen, 13/10/2020. This order already says that they can go ahead with the clearances and the action shall not be taken by the respondents without leave of the court. Now his grievance is that they are not processing the wildlife board. Wildlife board has to take a call in view of the application and take a decision. On account of pendency of this petition, they should not be this thing. As and when they get the permission, we will see what is to be done. 11/1, 11. Yes. Just 11/1. Yes.
Said we are notwithstanding the pendency of the petition, the application made by resistance service respondents shall be processed in decided.
Oh, yes, it's already there.
They don't want to touch it because they don't want to take the risk of.
No, but then this thing. What else can we do? We cannot decide your application here, right?
I appreciate that. But I believe
What? Take recourse to the remedy, if any law, what you have, whatever. There is no impediment.
I appreciate it. The reason why we came to your office with this application is.
What application? You have.
My application is only 1 of 2023.
What is it?
We have said, we have now pointed out that the amendment that they have carried out now focuses on the environmental impact study. Admittedly, the IEA was carried out based on EIA approval, the project was pulled out. Now he says that now there are subsequent reasons, therefore you need to take a fresh EIA. That is now the amended prayer in the repetition. So therefore, if that being the case, it is a matter in the realm of the NG.
No.
I have no difficulty.
What is the IA? What is the prayer?
So IEA seeks exclusion of the repetition. Now that the amendment seeks relief with regard to the Environmental Protection Act. Now in the light of what is going on in the light of the Your losses are not also the gains. I'm not talking about citizens.
No, we will decide the main this thing itself instead of the IA, then he is entitled to file this thing.
I'm not saying get fresh not to my prayer. I'm not, my God may please see but any good area which is declared as a lack of conservation reserve by the state of Karnataka.
What has been declared as black book?
Lack of conservation reserve under Section 36A of the Wildlife Conservation Act. The subject lands to which the project
No, but what do you say? The NGT has said that it's not a forest land. What you want to file reply to this IA?
I would beg your lordship for 2 weeks time to file a reply. I was under the Lord, therefore I did not file the reply. But in under 2 weeks time to file it.
This all public interest litigation, right? Please should don't stop contesting it as an adversarial litigation, right? And please, you should. Why we are telling you? We are telling this to everyone because what we have noticed, the trend is to fight it tooth and nail, right? So, I mean, this thing, the resistance on your sort, the vehemence with which you argue, we all notice this. That gives suggestion, not you, Mr. There are so many people sitting. We are telling everyone, not you in particular. Please understand. So this gives rise to some sort of this thing. We watch this thing. We have come across cases where so-called public activists who had filed, they are behind bars in connection with the scams. So we have learnt about it. So that's why. No. That's why, and please understand, you are here to assist this court, and we are here to find a solution to this legal issue. The project, which is in public interest, has to be set up in accordance with law. That's the only thing, that they have not got a clearance from the wildlife board. That's it. That's the only point at this point of time.
Small area available for animals.
Yeah.
Another can go outside. They will consider automated when they will process the application. Those are questions that have to be decided.
Yes.
Because EIA report does not even.
Mr. This, we don't think, Mr. Senior Counsel, paragraph 7 of this order, as is pointed out by Counsel for Petitioner, it's very clear. 11th of January 2021, it says that notwithstanding pendency of application made by 6th and 7th respondent shall be processed and decided. So if they are not deciding, please do. I mean, we can't. There's no impediment. Yes. Now, the long and short of it, as on today, you are seeking dismissal of petition. We have to grant him time to respond to him, whatever. How? All right. Which day? What is there 2 weeks? So what he has said, though he has told you, you have heard it, right? What is the objection? Just what? Tell us. No. Why he is seeking dismissal of your petition? What have you understood? No. So they are not proceeding. Therefore, it just should be dismissed. No, that means you have not heard him carefully, right? What did he say? Why he sought dismissal? He said that it's not a question of ouster of jurisdiction, but maybe perhaps the controversy, since you are saying that under the environment, just a minute. No,
Don't shake your head.
Making faces doesn't help. We see from here. My Lord has also seen that you are making faces. That gives us this thing. Making faces, you don't realize. We are seeing it. What is this? Relax. This is a public interest litigation. We are trying to tell you that we will deal with the issue in accordance with law. What is there to make face? No, that's what you are doing like this, making faces. Don't. You have not heard him. And for your benefit, we are not supposed to tell you what he has argued. Despite that, we are telling you what he has argued. And you are making faces. Your conduct is also as a counsel is under scanner when you appear in public. Appear in a writ appeal and argue as much as you want, but don't do it in a public interest litigation. Your conduct is also in the court is under scanner. The way you argue, we make out what is it. Right? So you file it within when you yes, Mr. Counsel, your which date? You are an outstation counsel, I believe. We believe. Yes, please, whatever you tell us the date. Monday. No, there's nothing to. That's what we were trying to tell you. You are seeking 2 weeks time. Nothing will happen in 2 weeks. The bench will not change. That let us assure you that. Number one. Secondly, the objection is not as such. You could have straightway replied. What is his submission is. Again, we have to tell you. Tell him. Ask your colleague to explain it to him. What have you argued? We are not expected to tell him if he doesn't understand. Oh, so but he's trying to tell us as if he is not understood. What has he? Why he has said that your petition should be dismissed? We are asking you. Yes, that's it. So simple thing is right. So you don't need 2 weeks for that. You understand? You have understood. File a reply in 1 week or whatever. Yes, Mr. Senior Counsel. So you tell us. You are an outstation. For us every day is the same, right? 10:30 to 4:45 every day. You tell us. And you are an outstation counsel. I come from a court where we have always given this privilege to an outstation counsel that he should have a date of his choice. That's why we are asking you. We will record his submission also that he wants a month's time and we are declining. Yes. No. You want this to remain pending, right? Yes. Fine. 26. He wants 2 weeks time, so we don't want to give 2 weeks, but first of August, first Monday. Then 6th is Saturday. Fifth is holiday. 9th. All right. 9th is also holiday. Any Monday? Yes. You tell us. 8th August. 8th August is fine. 2 weeks time is also there for you to respond. We wanted you 2 weeks, right? Do you get 2 weeks? Fine. Mark the presence. This petition which has been filed pro bono publico, the petitioner. When you are relief, Mr. Which page? Petitioner inter alia seeks a direction to respondent number 4 and 5 not to allot to divert any Amrit Mahal Kawal land in survey number 1 and 30 of Basu Kawal and survey number 34 of this all. Page 19. So for construction of Twentso Canal, direct the petitioners. How many petitioners are there? 3 petitioners also. All of them wildlife experts, right? Yes. Petitioners also seek a direction to. Why are you so serious? We want to see a smile on your face. Nothing is being done. You have succeeded in seeking an adjournment. Celebrate your success. Why are you so serious? I mean, we just asked her. All of them are wildlife experts. So she said yes. So why are you so serious? What you wanted in the beginning before senior counsel could say anything, you wanted 2 weeks time. Have you not got it? Is it not a cause for celebration? Celebrate your success. This is what the cases are meant for, to be adjourned. And public interest litigation least priority. So we should keep it pending so long as this court exists. Right? Fine. Don't be so serious. There's nothing to be serious. We are telling you, we are watching your conduct every moment in a public interest litigation, especially. Don't make faces, don't be so serious when it is being adjourned. We are only narrating facts for our facility. We have spent some time on this. So we are doing it for ourselves. Nothing is being done. At the end of it, you may please relax, sit down. Don't stand up. There's nothing is being adjudicated. We are only recording the facts for our reference. On the next date of hearing, no order is being passed. You are being granted 2 weeks time and the matter is being listed on 9th of August. Please sit down. Sit down, relax. Take deep breaths and relax. Nothing. Breathe in and breathe out, as my lord says. Relax. Fine. The petition. Sit down. Breathe. Yes. The petitioner also seeks a direction to respondent number 2 and 5 to both will take necessary steps for protection of Amrit Mahal Kawal land in survey number 1 and 30 of so and so, right? And to the petitioners, in addition, seek a direction to realign the proposed diversion and all to avoid so and so Amrit Mahal Kawal lands. You find out, madam, is there any possibility of diverting this canal? Is there any possibility or? Yes. So I mean, you just I mean, think about that possibility also. Yes.
Litigation, whether it's wildlife board or the forest board, they will that's their law. But and in fact, the intersecting extent only 2 kilometers. So litigation, there are certain kinds of litigation which is wildlife, you can take this is part of a particular site. So because it takes good body, you don't want to see all the right to the land as it works. Profit in the quality. That's not the issue. Now he wants to watch it.
That's how we can't. That's why we just thought of this relief and thought of. I mean, you must bear in mind this aspect also, and can get back to us online. Because, in this petition, the petitioners who claim themselves to be wildlife experts have filed this petition seeking pro bono publico justice. Learned counsel for the petitioner, inter alia, submitted that that for the project in question, that the submitted, the inter alia submitted that respondent number 6 and 7 have not obtained the wildlife clearance from the not obtained clearance from the wildlife board, and therefore they cannot be permitted to commence the project on whatever land, Amrit something land. What is it? Amrit
Kawal land.
Amrit Kawal land. Amrit Kawal land. Paragraph. On the other hand, learned senior counsel for respondent number 6 and 7 submitted that respondent number 6 and 7 are the instrumentalities of the state, and the project has been conceived in public interest to cater to the drinking as well as irrigation needs of the public in general. It is also pointed out that respondent 6 and 7 have invested a sum of ₹100 crores. While inviting the attention of this court to order dated 27/8/2014, passed by the National Green Tribunal, it is submitted that Amrit Kawal land cannot be defined as forest land. Full stop. It is also pointed out that against the order passed by the National Green Tribunal, a special leave petition was preferred, which has been dismissed by an order dated 99 page. 31st of July. Yes, yes, statutory appeal. Yes, not this thing. An appeal has been dismissed, not SLP. Appeal preferred against the aforesaid order has been dismissed by an order dated
31st July.
31st
Page
July
3 not
2015. Full stop. 31st July 2015. Paragraph. Learned counsel for the petitioner at this stage. Grace warrant is granted 2 weeks time to file objections, if any, to IA number 1 of 2022. Full stop. It is made clear that in case objections are not filed on or before next date of hearing, appropriate order shall be passed. List on 9th of August 2020.
Not 9th. 9th is already.
Oh,
8th.
8th August, sorry, 8th August. 8th of August 2020. You give a synopsis to us based of chronological sequence so that what facts, I mean, what happened when, right? We don't, when was the project conceived, what is the estimated cost, what is their grievance, how it has been addressed, which para of the NGT, where is it, which page number, like that. Give a brief note because, all right.
Well, Narayan, but okay.
Find the memo. Drop. Memo taken on record.
In the case, real proceed.
Despite no interim order, they are not proceeding with the project. What can be done? And there no interim order. Clarified.
Yes.
30. In the case,
Reply. You have to file SLP. What happened to it? No, Mr. Please understand that the remedy of filing an intra-court appeal or SLP does not give you license to flout the order, right? Where is the order of stay granted by Supreme Court? What is the law? Mere filing of SLP or writ appeal will not operate as stay of the proceeding. So if it has not, if the order is in existence, you have to comply. What is the order? No. So, Mr. Then we should wait for like 3 months whenever your SLP comes up. And then eventually, then if it is dismissed, then you will see 2 months time to comply. So, a 1 year plan for this contempt, right? Next year. So, we are granting you 2 weeks time either to file a compliance report or to produce an appropriate. We don't know. This can't be done. Very casually you stand up and this thing, writ appeal, this thing, you should have filed in anticipation, right? Mr. B.S. Sachin, the non-party petitioner, Mr. B.S. Sachin, learned counsel for accused number 1 and 2. On 24/2/2022, learned counsel for accused number 1 and 2 had stated that a writ appeal, namely WA number 191/2022, has been preferred. And therefore he was granted a week's time. Paragraph. Today, when the matter is taken up, learned counsel for accused number 1 and 2 states that writ appeal has been dismissed on 14/3/2022. Already 4 months, right? And against the order passed by the division bench, SLP has been filed on 11/7/2022. Full stop. Paragraph. In view of a aforesaid statement, 3 weeks time is granted either to comply with the order or to produce an appropriate order from the Supreme Court.
14. Government advocate on the HM only there.
Right? They complied or not complied? Applied, right? Yes. What experience? You are saying complied, right? What is that? Nothing, no instruction. We are recording and finding it is complied with what is there. Mr. This, please understand. See, facing of a case requires a human effort. I mean, if it is complied with, if you have any grievance, you can seek revival, right? What is there? If you are agreed, file a petition, do whatever you want. It's an interim order. What is the interim order? You do understand, right? What it has. You are saying that it has been complied with. Your client is not going to tell you it has been complied with. Please understand. It's like if you are hospitalized and the doctor asks you how to perform an operation on you, will you not feel scared? Huh? The doctor himself, whom I am trusting and who is an expert, doesn't know. He's asking me. So same way, your client will get an impression that my advocate is an expert in law. He's asking me what to do. Whether your client will tell you or you will suggest him. Making a statement. Do you think that he will put his entire career at stake for your one case and make a false statement at the threat of prosecution? He knows that it's a criminal contempt. You don't rely on your colleague. You rely on him, right? He is a good counsel, right? What he will say, he will not obviously tell a lie before this court. He understands what are the consequences of making a false statement, right? We are recording his statement. Yes, this petition has been filed for non-compliance of the interim order dated 15/12/2021, passed in the WP number 21397/2021. Learned counsel for the respondent submitted that aforesaid interim order has been complied with. The said statement is placed on record. In view of aforesaid, we are not inclined to proceed further with the contempt petition. The same is accordingly disposed. We have recorded statement.
Suresh Babu here, government advocate.
Which is 15. Report. What report? Science report. Let him file. What is it? What do you want to file? What he wants to file?
This is a
Counter. He wants to file counter. How much time? You said reply report. What report? It's counter, right? How much time do you want? Learned additional government advocate submits that he shall file a counter during the course of the day. Just in the next week.
15, the IPS, the extra register.
Apply. Oh. Yes. Mark the presence. Srimati Renuka, learned counsel for the respondent, submits that the order dated that in this contempt petition, the petitioner has complained of non-compliance of the order dated 17/8/2021, passed in WP number 4008/2018. It is also submitted that the aforesaid interim order has been stayed in WA number 1166/2021. It's in view of aforesaid submission. We are not inclined to proceed further with the content of this proceeding at this point of time. However, the same is disposed of with the liberty to the petitioner to take recourse to the remedy, to take recourse to such remedy as may be available to him, subject to outcome of WA number 1166/2020. Final order, not interim. Final order. Okay. Against.
17, the Randaswamy bid.
Not maintainable under Rule 26. RP. Learned in view of office objection, learned counsel for the petitioner seeks leave of the court to withdraw the challenge to the order dated 23/6/2021 passed in RP number 67/2021. Learned counsel for the applicant is permitted to correct the cost title within 1 week, list thereafter. The office objection is ignored, list after 1 week. Then you granted a week's time, then yes.
Plus 18, legal exit, government advocate.
What withdrawal? Oh. This petition has been filed for non-compliance of the directions contained in the order dated 7/7/21 passed in WP number 41853/2019. Additional government advocate has invited the attention of this court to the compliance affidavit in view of since the order passed in the petition, aforesaid order has already been complied with. Same not inclined to proceed further litigation. Contempt proceeding, same with this court of. Liberty, we have to grant the liberty or what? No, we can't permit withdrawal, right? Liberty is granted. They disposed of. With the liberty to the petitioner to take recourse to such remedy as may be prescribed to him in law with regard to his grievance, if any. Right? Yes.
19, Srinivas Babu,
Which number? No. Okay, this is contempt, right? They have filed something. Filed. Yes.
Question of the order is there is an illegal construction under Proceedings that must be demolished, and then we have to seek the permission for construction of the plan. But as per this order, they're not demolished. Leaving the authority and also not focus on this. Subsequently, they are that resolution number 3 sorry, the code has been applied for the plan, but construction of the masjid is a residential area. Subsequently, BBMK has granted the plan for residential construction.
What was the petition about? What was your grievance? Religious structure is the
That particular layout of that HBR layout is a residential area. Residential area, so illegal one masjid has been restricted. Similarly, you are private commercial litigation and all, where documents are getting subsequently after court has passed the order stating that though there is an illegal construction has been done, though that can be demolished as per this order. And the liberty has been given to the approach for such plan. As per that plan, the resolution number 4 has been applied for the plan. As per that plan, BBMK is sanctioned for residential construction, not for any other. In spite of that, they are constructing the machine in a residential plan.
So what is the direction issued by this court?
Page 18.
The structure is being constructed without any building plan. There is deviation. The same has to be demolished.
That is court treatment.
DPM. What? Yes.
2022 minutes. We are finding that.
What is it?
Initially, we gave notices. They corrected the deviated portion. Again, on inspection of them, they applied for a plan sanction for residential department, residential building. We are sanctioned the plan. Again, they deviated. Again, we issued the notice. So we have stopped the construction. Our plan is sanctioned. We have given the plan. We have also stated in affidavit.
No, what this order was passed when? Thereafter, what did you do? This was 21st September 21. Thereafter, what did you do? 21st September 21.
After what we conducted inspection.
When did you conduct inspection?
I did take my affidavit on 19/4/2022. I got 583.
Objection? No. What is it?
Of one to the Imran PA. Executive engineer.
Oh, yes.
Paragraph 83, paragraph 5.
Yes.
I submit that upon conducting the survey, the mother dated 26/10/2021 of straw. Photographs were taken, and the same were submitted along with the board for the opinion of the legal cell. The legal cell of BBMP opined to strictly adhere to the conditions of the honest dishonorable division bench in the PI and take suitable action. Paragraph 6. I submit that in support this point that cleared all the deviated forces, came to the extent of honest, and the BBMP was satisfied with regard to clearing of these deviations. As actually the plan made entry number 2 for on 19/1/2022 for the construction of the residential bridge. I submit that construction is now commenced and the ADTV zone of BBMP assures the honorable court that regular inspection with inspection will be undertaken and if there are any deviations found, the BBMP will initiate action in accordance with the provisions of BBMP Act. Because of it, in fact, even the construction of the new building, BBMP found that there was a deviation with regard to the height of the structure. Immediately, the BBMP issued notice dated 11/2/2022 under section 248(1) of the BBMP Act, calling upon the third appeal hearing to remove the deviated force. But paragraph next one. I submit that BBMP will perform obligated as provided in the Act and not quickly. And this is what we have done. We are now monitoring the construction for the plan which we have sanctioned. To that extent, it will be allowed. Anything beyond that, we will be monitoring.
What is a residential building means what? What is the construction being made? You will have to challenge, Mr. if you are agreed by this 19/1/2022 sanction plan. Now the order passed by the division bench was conditional one. If there is no sanction plan, 100% violation, then it should be demolished. Now they have this thing. They have said that whatever deviation was there, that was corrected. Thereafter, they have sanctioned the plan on 19 January 2022 for construction of a residential building, and they are monitoring the construction. So, like if you are now, in case you have any grievance, you will challenge this 19 January sanction. You will have to challenge in an appropriate proceeding, right?
Sanction plan. Notice the response number 3 is a trust. Knowingly, the BBMP has knowingly that allowed that sanction is residential plan for a trust. Response number 3 is a trust. So, knowingly, will to be there before the order of this court. Because number 3 is a trust. When we have quoted that in public interest litigation, we are made as a party as a trust. In the contempt petition also, we are a trust as a party. Not as any issue. Now, knowingly, when the application was submitted to a trust for a mercy, knowingly, we could be a sanction of residential plan.
We don't know. As on today, it's for a residential plan and it is being monitored by BBMP. That's the statement. Like
Last year, where is that? How you monitor? Where the deviation in the development that is came to?
No, if you see, if your grievance is that this construction cannot be done, cannot be made, then it's a different thing. And whether or not there is a violation, perhaps we cannot decide it in a contempt petition. They are monitoring it. They have granted a sanction plan. They have sanctioned a plan on 19 January 2022. The construction, according to BBMP, is being raised in accordance with the sanction plan. Like if you say that this sanction could not have been granted, construction cannot be raised on then you will have to take recourse to the remedy. In contempt petition, we can't perhaps, this is a subsequent event, right?
Clearly, where the plan. Though I made a party as a trust, not as an individual or not as an essential purpose. When my grievance existed was a trust. They applied for trust has been applied for the construction of the mercy. How that my request my lord, you could score with that. BPPS knowingly respondent is a trust. BPMP knowingly the respondent is applied for construction of the mercy. Knowingly linked to the BPMP has granted the residential plan. That's my only. They are complete, almost a minute. Actually, that has been completed. In view of the tendency of this contempt petition,
You will have to challenge it. Please understand. Yes. Okay, presence. Huh? When I was a counsel and when the judge did not hear me, I felt happy. Oh, not putting me. Do you think that we will pass an order against you, sending you behind the bars without hearing you? Huh? If you are not, I mean, he knows what is the order. He has told that I will have to file a fresh petition. You are intervening. All right, argue. What? No. Your clients are there. You have to play to the gallery, right? Please argue. Go ahead. Yes. Huh? What notice? You have challenged this sanction plan. Then what? Huh? What is this petition about? Tell us. Is it about a notice issued to you by the BPMP, or what is it about? Tell us. We don't know. What is? No. Hey, please argue now. Please argue. What is this petition about? Huh? Violation of order. Which order? Huh? Division bench. What is the order? What is the order? Which page? Page 18. What was his grievance? What was the what did he do? Like led to this order? He filed a petition. Yes, please argue. We are asking you what was his petition? What led to your just
because it is not a reconstruction. Again, there was a nothing more existing in the settled property. But after that, because it was in a realignment conditions. So, but without taking the sanction plan, plan was for approval plan was submitted to the delegation. Delegation, they have started construction. So yes, in the institution, yes, about direction that we can sanction plan are making deviations.
So in violation of the sanction, you have raised construction, right? That's the grievance.
After that,
So
this honorable court has directed the BPMP support there is a deviation right to the consent trust. So the plan section has to be issued. This is the order passed by the direction.
So what is the direction? Read it. What is the direction? Read.
The opposite.
No, which paragraph? Are you fully, Mr. B? Please. Para 4. 3. Yes.
The opposite investment makes it very clear that as per the tax survey, the responsible for is always constructing of the permission has not been granted. So conduct the building and there is another deviation of the eastern side. Keeping in the view of the building and submitted for approval, and there is a 10% deviation of the western side. The DVA case further stated that the opposite investment in case of action is taken for rectifying the opposite deviation. The DVA shall passing the appropriate order for grant of approval of respect in the building. So according to whatever the justification was there, your deviation that has been removed by me and sanctioned subsequently your trial sanction.
It was subsequently. When did you apply? When did you apply for a building plan? Which date? When it was sanctioned? Which date did you apply? You told us you applied which state, where it was sanctioned. We are asking you, when did you apply for sanction? Yeah, application, when you said we applied. So we are asking you, when did you apply? We will have to write this. This is all you have argued. This all you have argued. So when have you applied? August 20. You submitted an application. All right. So when it was sanctioned? January. 18 January. He told us 19 January. So which date? 18 January or 19 January? All right. Page 16 of what? Objection. Objection by the accused. Page which 16. Page 16. License and the no bidding license. Bidding license. And when was the plan sanctioned? Same day. Plan sanctioned. So, plan was sanctioned then. Huh? Order. What order? What notice? Notice to stop construction. Why? No, but we are not considering the validity of notice dated 21/4/2022 in this petition. This petition is for non-compliance of the direction dated 21st September 21 passed in WP, public interest litigation. So how are we concerned with the notice dated 21st April? So 21st April notice. So what did you do? So what is your this thing? What is your stand on deviation? They are saying that you have that's what he said. No, and there is a direction that deviation. Where have you said that there is no deviation from the plan? Where have you a objection? Where have you stated? Read para 4 of the order first, page 18. Read. Right. A considered opinion, not consideration.
Considered opinion. We take considered without any plan.
Yeah.
Amount for the employee who is granted certificates going to take up of it for a person, collective, whether only at a very significant in the week thereafter, and amount the element, and whether it is certificate or that, and therefore thereafter after it is sanctioned, when the certificate is to consult as per the sanction, not approved by the.
So what corrective measure have you taken after the order was passed within 30 days?
Whatever we don't have passed by the scrutiny, the reasons to demolish to the another facility that has been demolished by you.
Where is it? When did you demolish? You demolished or BBMP demolished? You have demolished. When did you demolish? And what is the information?
I demolished on 2010, 2003,
One
2003.
demolished. And you submitted an intimation to BBM when
On 25/10/2003.
2510. Then what happened? You applied for this
As per the order of this was not after the
building plans. You applied.
Now, they said because there was something called a review of the notice. And said there is a one thing for the high, there is a deviation. Because validity is given by what we actually have. That all is
So what is your stand? Are you constructing in accordance with the building plan? You said the 11 feet height and 14 feet you have constructed. Huh?
they say it is 11 feet, 14 feet, 11 feet is 11 feet.
Measure, Mr. Find out what is it. We will keep it pending. You are saying that is 14. Which order? 48. Which order? 21/4. Which? What is that order? You have to place. You are telling us. Petitioner and BPMP is not concerned, but you are telling us 21/4. So if you are arguing, so you place it on record. No. Why you should not argue? You have a right to argue. You are telling us 20. You have told us 21/4/2022. Now we need to see what is that order because you are making a reference to it. Which order? Yes. Where is that? Place it on record. This petition has been filed for non-compliance of the directions contained in the order dated 21st September 2021, passed by Division Bench of this court. Learned counsel for the BBMP submitted that in pursuance of the order passed by a division bench of this court, respondent number 3 had submitted an application for a building plan which was sanctioned on 19th of January 2022. Full stop. It is further submitted that BBMP is now supervising the construction, which is raised by respondent number 3, supervising the construction to ensure that the construction is raised by respondent number 3 in accordance with the building plan sanctioned by BBMP. Full stop. However, learned counsel for respondent number 3 submits that the construction was raised without obtaining the building plan. However, the same has been demolished on 1/10/2021, and thereafter the respondent. It is further pointed out that thereafter respondent number 3 has submitted a sanction plan on 4/8/2020, which has been sanctioned on 18/1/2022. What is it, Mr.? How it is? He's saying 18th, you are saying 19th. What is it? 18th or 19th? What is it? 19th? 19th. There is no sanction plan, right, on 18th. You are saying, learned counsel for respondent number 3 shall produce the copy of the building sanction plan, if any, on 18th of January. Oh, no, it is further. Before that, you write, it is further submitted that a notice to respondent number 3 was issued on 21st April 2022. 22. When a query was put to learned counsel for respondent number 3 about the notice dated about the opposite notice issued under section 248 of the BBMP Act, how much time do you want to produce? Weeks. Learned counsel for respondent number 3 press one is granted 2 weeks time to enable him to place on record the copy of the sanction plan, if any, issued on 18/4/2022, and copy of notice issued under section 248 of the Act. What Act? 248 of the BBMP Act, dated 21/4/2020. This stuff.
I appear for complainant, my lord. Annexure A is the order passed by the learned single judge, my lord. Operative portion at page 12, my lord.
Lighter work. Yes, what have not allotting him lighter work. Then. No. They see this all directed to take appropriate decision to light work to in accordance with Act 95 within 6 months. So, no, which, just a minute. So, when have you, which order you have given him light work after? Lighter work, not light work. Lighter means asking him not to do anything and paying him salary promptly. That is what is lighter, not light work. So what is that order?
Malad, after passing this order, Malad, you was accommodated light work only for a period of 6 months, Malad. From January 2022 onwards, Malad, he was kept out of duty. Till today, Malad, they have not taken any decision as per the direction of learned single judge, Malad.
So what is the date of order by which you were given light work, or lighter work, whatever it is?
Yes, Malad. Malad, earlier to this order, Malad, you was accommodated light work only for a short period, Malad. Therefore,
you were required to take a decision. When have you taken decision date? I mean, simple, right? 17/6. No. So that means you have not complied, right? That means what? Please read, Mr. Operative Portion. Please read it for your benefit. Read it. No. Read it. What is the direction? So the period of 6 months has expired on 17/12/21. When have you taken a decision? What is the order? Order? Not order of this court. You have to take a decision. To take appropriate decision. Simple, Mr. What is it?
We have already taken. He's already working.
No, he's not working, Malad. He was kept out of duty from January 2022 onwards.
Again, read the order. Again, read the order. Again, read the order, page 4. The decision can be on the file, it will not be, but here is it. Okay. Not 6 months. Corporation is, again we have to repeat. Please read it. Stop. Where is that decision? Simple. Which date? You can't tell us the date. Within 6 months, you have to take it. That's the simple thing. We are right from the beginning. Third time we have asked. Where is that order? No, light work.
My lord, there is no direction to refer the petitioner to the medical board, my lord. Despite, my lord, they
That's a
have,
different thing. That's a different thing. But
please,
there is no direction either not to refer you to medical.
please.
So,
And the last two lines, my lord,
where is that order?
my lord, last two lines, my lord, operative portion. Till such proceedings are completed, petitioner shall be provided with lighter work. But they have not provided lighter work, my lord.
Lighter work means no work, right? No work. No work means they should not assign any work to you. That's what it means. What have you been doing? What are you?
My lord is doing some clerical work, my lord.
It's not light work.
Yes, my lord, that is light work.
Light work. No, Mister. I think you have not got it. I mean, you have not been able to explain it to your client. What is the purpose? No. There is no, Mister. Where is the order? Then that's the end of the matter. There is no question of any dispute. No. Again, read the order, page order. Please read it again. Well, we think we are getting it wrong, and it is very clear to you that it means no. According to you, it means producing attendance register and payment of salary. That is not his grievance. He did not say that salary has not been paid to me. Again, read it. Again, please read it for our sake. We have not got it. No. We have not got it. We have not got it. Please tell us.
Within a period of 6 months from the date of receipt of this order. This order is passed in the month of June.
So, when have you taken a decision? It is not his grievance that he is not being paid salary. It's not his grievance that he is not being permitted to mark attendance in the attendance register. No, again, please read it for our benefit. Please read it again. The respondent corporation is directed. You have just now read it. Please read it again. We are not getting it. Not letter of appointment, appropriate. Again, read. That's why we are not probably clear. So please read it again for us, not for you. Please again read it. Respondent.
To the petitioner in accordance with that letter, I will produce it.
Within a period of
6 months.
So that means 17/6/21 was the order. Within 6 months, you had to take a decision regarding providing lighter work. This is what we understand. Now you are not producing the decision, right? So what should we do? You tell us. Appropriate decision. We will record the statement that you have taken decision. Learned counsel for respondent subjects that appropriate decision to provide lighter work to the petitioner in accordance with the provisions of the persons with disabilities within bracket equal opportunities, protection of rights and full participation, bracket close, Act 1995 has already been taken. However, the press warrant is granted a week's time to enable him to place the aforesaid decision on record. List on 4th of August.
My lord, one submission, my lord. Last two lines, my lord, till such proceedings are completed, petitioner shall be provided later work, my lord. But they
That
have
also you
not.
have to, that also lighter work he has been, what work we have not heard. And what is lighter work, what the work he is supposed to do. So what is supposed to do and what is this lighter work awarded? His grievances, you should not ask him to work, right? He should. That's his point. Lighter work means no work. Hey, you don't trouble him by calling you. Send the attendance register to his residence. Send his attendance register to his residence along with a paycheck. That is what is lighter work.
No, my lord, January.
Yes. That is your unreasonable in asking him to come to office. Why should he come to office? He has got an order from the High Court, right?
Right, January 2022 onwards, my lord.
Now we
You
have
was not
understood.
paid salary. You was not paid salary. You
No,
was
that is not
accommodated like.
No, we will
Please.
not permit. I mean, since the counsel for respondent was not clear, that's why it has taken so much long time. We are clear about it, that they had to take, and in case he has made a statement and we don't find any reason to disbelieve it, and therefore we have granted time. In case he is unable to produce that decision, then we will proceed against the person in accordance with law.
Please.
Simple, right? Instead of attendance register and all that, you should have told us that on this date we have taken this decision. That's it.
Please.
Number 21, Dinesh Kumar and
Yes.
Order contempt they know.
Yes.
Second, Naraka, by our interim directive, in order that the respondent shall not find the check. Check number below. If the matter comes to number 4, we continue to review before expiry of the period of validity of the check. Now, there is a brief background of what happened in this area.
He is the respondent in this.
He was directed to furnish security.
All right, yes. He has not done so.
10 post-dated checks were given pursuant to a distribution agreement between the two parties. Now, 4 of those checks bounced for 138 proceedings. At that stage, the accused filed a Section 9 application before the commercial, requesting for a direction to us not to encash the balance 6 checks. The commercial court issues an argument direction that yes, don't encash the checks, but please provide security for the value of those checks. Now, he provides security for 2 of the checks. The balance 4 checks, he approaches dishonorably. In fact, he files an application to file fresh checks, that also is rejected. Then he approaches dishonorable in a commercial.
So he furnished security in respect of two checks.
Only 2 checks. The checks in question before we come into the commercial appeal. Check numbers 51 to 54. There were 4 checks numbers approximately for an amount of about 2 crores.
So he was asked to furnish a security in respect of these 4 checks.
In fact, 6 checks. For 2 checks, he gave security.
No, the order is in respect of what?
These 4 checks.
4 checks.
Numbers 51 to 54.
This is the order, 24th January, right?
That's right. 24th January. The last of one time, learned advocate from the FLA, and is directly in this proceeding, undertakes to give security in respect of check number 50. That is not an issue. In fact, there is subsequent issue, but not reformed by law today. To the satisfaction of the commercial.
Like 4 checks, 151.
Those 4 checks.
All right. So
the important portion of is before the expiry of the period of validity of the checks. Because these were post-dated checks. This one will be conscious of the fact.
no, fine. So
expire, and I will have.
all right. So he didn't give.
That's right. He did not. In fact, he went to the Honorable Supreme Court, except he also came to be dismissed. Then subsequently, the commercial appeal came to be dismissed on 29th March 2022 because nothing survived for consideration. Therefore, my respectful submission would be the content is glaring on the face of it because admittedly we have not punished security even today for these 4 checks. Now the problem I'm faced with is these 4 checks have also expired. These 4 checks expired between February and March of this year. Therefore, it's a simple yes or no answer would be no, we have not provided security as of today. Next question would be, what is the remedy available to me if I can request this honorable? But the answer is that to be recently, when Dr. Vijay that case, the Honorable Supreme Court noted the fact that there is a series of judgments. It says that the container should not be placed in a position where he advantages from his continuation conduct. And therefore, any advantage that anyone will benefit should be reversed. Therefore, Manoj, the only way, in my respect, is
Please check.
The benefit of the order did not enable to me. The initial order that was passed by the Section 9 court member.
So we are concerned with 24th January 2020. It's not a conditional order. No, it's 24th January 2022. It's not. What is the conditional order? No, I mean, forget about it. We are asking you what do you understand by a conditional order?
I were to deposit security prior to the expiration of the check member, I would get the benefit.
So supposing the court would have said that if you deposit the X amount by say 31st of August, the check shall not be encashed. This is a condition. This is a conditional order. This is not a conditional order. You have given an undertaking before the court.
And I have expressed my inability to give.
No, Mr. You should do it, and you are a counsel. We are telling you, you will, as it is, you have landed in an unsavory situation. I mean, you are personally, if you are the counsel, I don't know whether you had appeared on 24th. You have landed yourself in trouble. I mean, you have stated on behalf of the appellant. You should have said the appellant undertakes to furnish. You say you have undertaken. How?
It was undertaken on behalf of the appellant.
That's what we are telling you. As a young person, you should be cautious, more cautious. Mr. Vikram is appearing, otherwise any other person would have said that he is personally liable. He is fair to the court and he is a senior counsel. That's why he has not raised this point. Any other person, any other counsel in this place would have argued that he would have impleaded you. Please understand. Don't involve yourself. You are not into the litigation. You are not a party. Nobody is giving you license or cancelling it. Don't. That's what you are a young man. That's why we are advising you. None of our job, but telling you by way of a caution, don't do it. So now what happens? These checks have to be. You have to purge the contempt, otherwise face the music. Answer is simple. It's all this conditional argument theory we are not prepared to buy, and it can't be done. So who is the managing director? It's not possible for him. The persons, director, live sports, this thing, all these persons will appear. Should we issue a available warrant or will you produce them?
What my stance is,
No. Of course, take 5 minutes. Feel free, but argue this thing. Don't argue that it's a conditional order. It's not a conditional order. Read it again, 24th January for our benefit. Where do you get it from that it's a conditional order? No. You have, by furnishing an undertaking, you have misled the court and you have got away with this. The checks have expired. No. Read it. 24th January, read the order. Read for our benefit.
For the appellant undertakes to give security in respect of check number 578050 for rupees 5 lakh. In respect of 051 5253 54.
So order has 2 distinct parts. One part is by way of interim direction, not to bank the checks, right? Other direction, other order is recording your other part of the order is recording your undertaking. These are two separate and distinct and are not correlated. It doesn't say the respondent not to bank the check subject to furnishing before expiry of validity. It doesn't say so. It's not a conditional order. Please.
The relevant period for which the last date of this section, I have taken recourse to the SLP which was available.
That means
That if I may
SLP Supreme Court has said they don't pay the amount, right? While dismissing your SLP. Then what is it? SLP has been dismissed, right?
this has reported to the court before the expiry of the period for the next check which was to be ended.
No. This one.
If I may invite your attention to objections.
What is it, Mr. In substance for not complying with? You understand, right? We have also, as counsels, Mr. We have also faced tough situation. The answer is not to argue anything which doesn't make sense. You understand, right? There are two parts. One order is grants you stay. The other order is records your undertaking. You have not complied with the undertaking furnished by you. That's it. So then, no, nothing. Undertaking is furnished to this court, not to commercial court. So what you do before commercial court is this thing. So no. So what this check was issued on? 4 checks. All were issued on same dates or different dates. The 5-1 was issued with. 15, 11, 21. What is this thing validity? 13th February 22. Next check.
29/11/21. 27th February.
Next.
December 21.
Yes.
15th March. Check number 54 dated 29 December 21.
28 March.
The last check, the submit that since the commercial appeal is decision check was in and 138%. So really 3 checks are.
3 checks. Yes.
The dates are slightly different.
Different.
Not the date of the objection, the date of expiry is slightly different. There is the checks are valid for 3 months. The date which is 15th in contention, 15th November 2021.
This is calculated properly. What date?
15th November 21 check, expires actually on 15th February 2020. 29th November 21. It's same day, 3 months. 29th February or 2nd March 2020.
So what is the 29th November when it expires according to you?
29th November, that expires. That one probably may because it's 3 months,
What is it? Tell us. I mean, don't expect us to count. You tell us.
27th February 2020.
That's what he told.
The person
15/12.
is 15 months.
By correct? Good. So in 2 cases, it is certified that you are correct. Yes.
If I may invite your attention to one.
No, what is it, Mr. One thing is in the just a minute. I mean, in contempt proceeding, what could be the possible defenses? We don't know what you are trying to argue. You have argued so much now, and you have not come anywhere, right? What is your defense? Is it your defense that this order you have complied with and furnished security? You are not complied.
For these,
Then
there is no useful default to the argument.
that we will determine, right? Let them appear. Who is the person? All these persons will appear. So one obviously can't appear. One. So 2, 3, and 4 have to appear. They are living persons. So when they will appear, tell us. No, tell us. Yes. No, I mean, Mr. Counsel, you must learn. I mean, see, if you can't tell the court within 2 minutes what is your case is, the chances are you won't be. Now, after we are put this thing, we have made up our mind. You have not told us. You should have, in the beginning, you should tell us that, sir, my defense is that I have complied with the order for these reasons. That's it. Or I have not complied with for these reasons. You are not telling us. Now you are saying last order, what last read it, whatever. Why last? Read as many as you want. The order we have told you what is it. And we will only ask at the end. Well, please feel satisfied, but you should not. You should know the art of, arguing a case. That's why we are telling you. Fine. Which order you want to read. So you have not complied with, right? It is also not a dispute that you have not complied with the undertaking. Fine. 64. What appellant? I so and so 34 years authorized signatory of the appellant 305 do hereby declare best of my knowledge. This is 34, 64. This is verification at page 64. This is what is 64. You said 64 of memo of appeal, right? The petition. Affidavit. Page 64. And then say so, Mr. Be clear about it. We are looking this petition 64.
Number 65 on it,
65, 64.
64 if I'm not relevant part 65.
Commercial code. It is ordered 25th January.
Not 14 to 2022. Next page.
14 to. Yes. 65. Yes.
This order is 1 day prior to the expiration of judgment. It expires on 15 to 2022. My lord, here I report that I have not been able to comply with the order which is in question. Hence, I have filed SLP, and that SLP also I have not been able to get any relief. SLP is dismissed. Inability to comply with the order, my lord, is reported to the court and to the other side on 14 to 1 day.
What you should have done? Inability, if any, you should have rushed back to this court. That, sir, I am bankrupt. I don't have money to eat. So therefore, I cannot do this thing. So what bona fide conduct? And it doesn't say any this thing. It doesn't say state of any inability. Mr. 14th February is not any inability. Read it again. Read it again. No inability. And in any case, commercial court could not have done anything because undertaking was furnished to the High Court. You could not have, you could have gone to Chennai, some court in Chennai, and said that, sir, I have no money to eat, please provide me money. Then you should have said that, though this division bench of this court has granted, I have told the court in Chennai that I don't have money. It won't help you. Undertaking was furnished before the commercial court.
No.
Before the High Court. Which court could have altered that condition?
Court could have altered the condition, hence I filed SLP, it was dismissed.
That's the end of the matter, Mr. We don't know what are you arguing. We really don't know.
On 14 this check could have been deposited by the complainant. On 14 the check in question could have been deposited by the complainant. The check could have been deposited. There is no order in this. This is the point I'm trying to do.
So this is the first point you should have tried to make. First sentence, you should have said that, sir, I'm trying to make a point that there plenty of time and enough time they did not this thing, therefore I cannot be held up for contempt.
In fact,
despite violating the undertaking. This the
My lord, I could have been more clear.
this is the only thing which you should have said, which is you are saying at the end of it when everything is over. This is what is the this is what is called Mr. Counsel experience. This is called perhaps you are ill-equipped to handle this case. I don't know whether you should have. All right, go ahead. Whatever you have to argue. So 14 to what? 14 to what does it say?
That I filed against the order of commercial appeal by this court.
No.
I filed an SLP which is dismissed, my lord, and there is
Okay, you have brought to the notice of the commercial court that SLP has been dismissed. That's it. So what?
but
So thereafter he had like he had time. He should have encashed the check.
subsequent pages, my lord, the first chance that I had completed arguments on merits, my lord. If my lord turns over the pages, my lord, or turns over the pages of the operation, my lord, next few orders, my lord. I have argued on merits in the commercial court, my lord, on the next date of hearing.
No, nobody is saying that you have not argued on merits and this thing, and you are dragging on the matter. Please understand, I mean, the scope of this proceeding, like that KSRTC counsel, we have to make you read again. Please read it again. He read 4 times. Simple thing. You also read it once again and tell us what is the scope of this contempt petition. Whether you have argued the merits matter on merits before commercial day, court on which day is the scope of contempt. Is he saying that on that day you did not argue, therefore you should be sent behind the bars? What is the scope? Please read it again for our satisfaction. We have not read it. Please read it again. 1424.
Appellant counsel files memo with CC of order dated 24/1/2022 is commercial appeal 44 of 22. Respondent counsel files statement of objection to of document, serves copy on the other side and submits the security deposit towards check number 788051 dated 15/11/2022 for 50 lakhs is not furnished by the applicant.
Read further.
As per the orders of the Honorable High Court, appellant counsel submits that he has filed SLC against the order in commercial appeal 44 of 2022 and the same is listed for admission. This is a submission in the morning.
Where did you? I could not pay and all that is not there.
My lord, that I have not furnished.
Huh?
I have not furnished security. DS line number is not furnished by the appellant. Check number 24 dated 15/11/2021 for 50 lakhs is not furnished by the applicant.
No. So not furnished is the end of it, right?
End of it.
End of it. You should say before the court, I did not do it. Say that I can't comply with it. That's it. That's the end of the matter, right?
Because the submission
No. Perhaps we are not clear to you. You argue whatever, but before arguing, again read page 18, 24 January 2022 order. What is it? Who has passed that order? Please read it. So commercial court has power to modify the order. Did you file an application for modification of the order, or merely making a statement that I did not pay the amount is sufficient to discharge you of the undertaking before? Is this your submission, that I made a statement before commercial court that I did not deposit the amount, therefore I am discharged of my undertaking furnished before this court? Is it the submission?
No.
Then what are you saying? What are you arguing? Please, do you know what are you saying? What is your case? No, he said to take 10 minutes, but we are trying to make out what are you arguing. We want to understand sincerely. You have not. First submission you made was that they had time of 1 day, they did not encash the check. That we have noted down. That doesn't help you. What is the second submission?
Not complied with benefits I didn't get. The second one is that there was no willful distribution. There was no distribution.
How?
The order under consent, I'm getting undertaking.
Please read. Please read.
continue to do so in respect of check number 294 before expiry of validity of judgment. Security based on the orders of this court to the satisfaction of commercial court.
Now, how is it not a disobedience? You have not, it's not your case that you furnished the security. You have not furnished. Huh? The please means no. Not please means please can be yes or no. Say clearly what is it. Please means what please?
78050 are furnished now. The next 3 are
Not furnished, right? So then how is it a compliance? How is it a no? You are saying it's not a disobedience. How? Why not? Please, mister, you are running out of time. I mean, you are saying all sorts of things. We are just, why we are speaking, we would have heard you patiently, but we want to understand. We are telling you. So he is also tired. He is also tired. He has sit down. He sat down. Huh? Finish, mister. That's an indication to you. It's not a case which is so complicated that we are required to adjudicate the validity of some statutory provision or anything. Not interesting. It's only a case of an undertaking violation. So does it say that it does not amount to violation? But which case law? What is this? Is something list of dates. What is this? You have to tell us what is it? What is it? Which? What is the proposition?
This is the proposition which my lord asked me not to argue. It is a conditional order proposition.
What to argue? We can't prevent you from arguing. You argue, please. But we have told you, we thought that you are a young man, so you will be reasonable and you would understand. If you don't want to understand, we will deal with it, that it's a conditional order. Which paragraph? No, mister, this we will not permit, we will throw it out. You have not told us what is the citation, what proposition, which paragraph. You can't pass on like this judgments, 100 judgments to us without telling us. We will throw it out. You have to tell us. Please go ahead.
Invite your attention to page number 3, which is related to additional order number.
What Allahabad High Court? What is it? Single bench of Allahabad High Court. Who will tell?
Say that.
No, some problem, Mr. Counsel. Some problem with you? No problem, right? Please, we will not interrupt now. We will not say a word. Please go ahead, whatever you want to say. You should have the satisfaction because your client is at the receiving end. You should have the satisfaction of having argued the case. We will not say anything. We were trying to interact, thinking that you will understand, but it doesn't. You go ahead, whatever you want to say, we will note it down. Yes. What is the citation? Just now we said we are waiting with pen, this pencil and this citation.
All the 3 propositions are with respect to how conditional orders have to be interpreted and how benefit of that has to be taken by one side or the other, and whether violation of unconditional interim order amounts to contempt under the Contempt of Court. First citation, Narayan versus Lara Adjournment. Page number 3, paragraph number 7. Paragraph number 7.
This is not the way, right? You shouldn't do like this. A copy given to the court with marking. Don't do it. Right? Good. Future, we are telling you, don't do it. Yes. Go ahead. You have given your copy to us. Fine, fine. Please separate.
Unmarked copy.
Give it to him. He may not be having it. So it's not all right. We got it. Conditional order. If the condition is not fulfill the order stands vacated, a person cannot be punished for contempt. Fine. Thank you. So what decision 76 and what is other one?
The other one,
Huh? What all single benches, right? All alone. And what about Kerala High Court? Why Delhi? Delhi has more force, right? So even single judge is binding on us on a full bench of Karnataka High Court, right? Huh? It's not proper, Mr. Counsel. You are a young man. This is not proper to cite a single bench decisions before the division bench of a high court, and that too, if you are citing, seek permission. These are the manners. Mr. Vikram, who will tell these people? You have to, it's high time that you should come up with some sort of an orientation thing. Who will? Yes, what to do? Who will, I mean, whole day we keep on telling this, you see what is happening. Yes, which other decision? No, this is what 2055. Hey, Mr. Who will tell? It's not saying Delhi. We will throw it out, Mr. This citation, these bunch. You are not telling us, not doing anything, Delhi High Court and all that. We will ignore this. Right, go ahead.
I'm not saying it is binding on this one.
No, we are telling you that you have to cite a decision. Passing on the bunch is not the way of this thing, right? We will discard it. That we will say that in the order that you have passed on the bunch and you have not even referred to this and you have not told us anything about these citations. We will discard it. How many times we told you that we are hearing you, again you make us speak. Are you not concerned with Narayan Singh and Ram Singh, Mr. Proposition of law? Whether Narayan Singh will make any difference, name, or it's the proposition of law which is laid down. Supposing if name would have been Ram Singh, would it make any difference? So what are you doing? You don't know how to cite a case also.
May I take instructions on permission of fresh text? Can be granted 1 minute?
Nothing. This is the attempt which you have been making. Too smart. Right? We thought you're a... No, got it. Yes. Go ahead. No, it will not be adjourned for a second. Forget about it. You just now sought the adjournment.
Conditional stay is 100 million and it is not complied with. It's not a contempt of this.
Fine. So that is the proposition. It's not a conditional order. Thank you for your understanding. What else?
The disobedience part of it.
So cost we will follow, right? Whether you pay it or your friends will pay it, that's a different thing. Now you are bent upon wasting the time of people. We will give you time. What disobedience? You have said that there is no disobedience. You have complied with. What is it?
I have not given security alone, but I have informed the court that I am unable to pay the security alone. Commission is that on the day.
You have not informed. This is wrong. Order sheet doesn't say. Fine. All right. What? Commercial code, therefore, there is no disobedience. You have informed the commercial code, therefore, there is no disobedience. What else? Thank you. Yes. Market presence. Mr. Vikram Huliwal, Senior Counsel with so and so. What? One by this side, one. What is the secret? He is appearing independently. Huh? Instructing counsel. Oh, so you should come here, right? You should stand there. Oh, yes. Yes, Mr. Vikram Lalit, Senior Counsel with Mr. So and so. So and so correspondent. This petition has been filed for non-compliance of the undertaking furnished to this court on 24th January 2022. Past it. Undertaking furnished to this court as contained in the order dated 24th January, right? As contained in the order dated 24th January 2022, passed in company commercial appeal number 44/2022. The aforesaid order is reproduced below for the facility of reference. Paragraph. The paragraph. Thus, it is evident that the order is in two parts. The following two parts. Number one, an interim direction has been issued to the respondent therein not to bank the checks. Number two, and the undertaking furnished on behalf of the respondents is recorded to furnish security in respect of checks bearing number so and so 788050 for rupees 12,50,000 and security in respect of checks bearing number 788051 254 to the satisfaction of the commercial court before the expiry of the validity of check. Full stop. The aforesaid line below. The aforesaid order is not a conditional order. Full stop. Continuation. Admittedly, comma, the security in respect of furnished, Mr. 50 is furnished. All right. It is not in dispute that security in respect of 788050 was furnished by the respondents. Full stop. However, admittedly, the appellants, admittedly, the respondents have not furnished the security to the satisfaction of the commercial court before the expiry of the period of validity of checks. Full stop. Paragraph. Learned counsel, expiry of the validity of checks, that is on 15/2/2022, 27/2/2022, 15/3/2022, and 28 March 2022, respectively. Learned counsel for the respondents submits that the order dated 20. Delete that sentence. Learned counsel for respondent submits. Submission will come before after the quoting of the order. Their submission. Learned counsel for respondent submits that the order dated 24th January 2022 is a conditional order, and therefore, if the condition prescribed therein has not been complied with, the order ceases to operate. It is also submitted that the respondents have challenged the order dated 24th January 2022 in a special leave petition, which has been discussed on which date 14/2/2022. It is further submitted that on 14/2/2022, the appellant had informed that in respect of respondents had learned that respondents had informed the commercial court. Respondents had informed the commercial court that security in respect of check number 788051 to the tune of rupees 15 lakhs is not furnished by the respondents, and therefore there is no disobedience of the undertaking furnished to this court as recorded in the order dated 24th January 2020. The submission now become after the order. Then what have you written last sentence?
However, admittedly, respondents have not furnished the security to the satisfaction of the commercial court issue before the expiry of the period of validity of the checks, that is on so and so dates.
The order has not published. Therefore, prima facie, prima facie, a case for after his submission, to record before his submission, to record senior counsel for senior counsel for the petition submitted that the respondent should furnish is under an obligation to first the contempt, and to submitted that respondents have flagrantly violated the undertaking published to a division bench of this court as written in the order dated 24/1/2022. Full stop. It is further submitted that now it is further submitted that the respondents cannot be permitted to take advantage of the order passed by this court, and they are under an obligation to first the contempt. Then it is submission. Then everything else will come. Respectively. So, therefore, therefore it is line below. Therefore it is. When they will appear? Third order. Therefore, it is directed that the court can appear because the court on 3rd of August 2021, learned counsel for 22, right, 22. Learned counsel for respondents undertake assures this court that respondents to the court shall remain present before this court. List on 3rd August 2020. We'll have to provide them some legal aid, right? Engage a senior counsel on their behalf. He is not a position person. He's testing it as not about a situation. We thought probably they are not properly informed. I mean, he is not in a position to assist.
At least now he can check.
That's why you have to apprise them, Mr. What are the consequences which can ensue for non-compliance? Provided, I mean, they volunteer to go from here to somewhere else, that's a different thing, right? But still, we have recorded. We don't know whether let them appear. We'll provide them some. We'll engage a senior counsel on their behalf to assist us. We don't think he can guide them properly. Any other counsel, Mr. Had he been represented by a senior counsel, they would have done so. But that's why we are saying that we want to give them a fair chance. Setting them behind the bars is not a solution to the problem. He doesn't understand. What can be done? No, don't offer. You be apologetic to your clients that because of your arguments, they are required to appear before this court on 3rd August. Fine. Thank you.
22, 13%, Sri Mohan Chandra P. Government Advocate.
Yes. What is it, Mr. Rita P? Fine. That's good. What is it? That's fine. What is it? Leave. What? Why? Challenging the appointment as Chief Information Commissioner. What happened to that rate appeal 3775, Mr. We will list it along with that. WA is pending, right? It is rate appeal 3775. It has been decided. We will list it along with it. We are not doing anything, Mister. We are listing it along with records of WA to see what has happened. Party in person list along with records of WA number 3775 part 2019. Which date will you come? Which date? Next week? Any day of your convenience? 27th? It's on 27 July 2020. Let us see. Wait. Huh? WP. Where is that order? 19. Why you did not say in the beginning? You were saying that this is all office objection and all that. You should have told, right? Huh? No. Supposing if we would have allowed your appeal, you would not have said anything. Kept quiet, like taking chances. Not fair, Mr. You are an advocate. You want to yourself to be appointed as the State Information Commissioner. Then, supposing even if their appointments are quashed, what will you get? You will stand wherever you are. What you are an advocate, you owe a duty to be fair to the court. What is fairness? First instance, you should have told, my lord, may kindly see page number so and so. When we said we started reading, then you felt, oh, something is going wrong. Judges are reading, they should have allowed my application for condonation or delay. Not fair. Which page? Oh, you produce that. Learned party in person. Which order? 21 2145. Party in person prays for adjournment in order to enable him to place on record copy of order dated 3/9/2019 passed in WP number 21456/2019 and WP number 8291/2019. When will you file? Oh, why? You just now you said 27th. You just now you said 27th, right? 27 July. Praise for the granted. What is the hurry? 3 days time to place on record. Granted 3 days time to place on record copy of so and so list on 27th. So that's what you said. We keep on hearing cases. There's no problem. There's no this thing. We will not insist. But what we are telling you is that you should be fair to the court. Always be fair, irrespective of the result of litigation. Always be fair to the court. You should have said in the first this thing. Please. You took a chance. Not fair. We will remember this now. That you are not fair to the court. Supposing if you would have allowed your writ appeal today, would you have said? You should have said. At least see page number so and so, or you should have produced the order. You did not produce that. When we started reading the order, then you thought that something is wrong. My appeal may be dismissed, so that's why you said. Why it's a court hall moved matter? You knew this is a court hall moved matter, right? You mentioned memo.
23, 30%.
What is contempt? Fight.
These are statutory notices, including the 248(1), 2, 3. Stating that there is legality of construction.
Appropriate action they have taken, you challenge it, Mr. There's no problem, but you need to challenge that. There's no point in keeping it pending. He is favored. He is interested in keeping it pending, right? What can be done? We have enough space. So after it will come up, why 1 week, 4 weeks? Fine. First of all, you want to go through, right? Go through leisurely. There's no problem. Party person, Mr. Shri, praise Mr. Shri, we learned counsel for respondent, states that he has filed a compliance memo. Learned counsel for the party person prays for and is granted 4 weeks time to enable him to go through the same list after 4 weeks.
And Vatan Kumar K, government advocate.
Weeks. What is it? What is it?
By 25, the Ali cannot.
2 weeks. Why? Constitution bench. Translation. 4 weeks. Not constitution bench. You were trying to say that it should be heard by a bench of 5 judges, we thought. 4 weeks.
Number 26, the Nayak Samidhanam.
How much time? 2 weeks.
27, the Rakesh Gilbert.
Each time.
28, the Narendra Babu Dike.
2 weeks time may kindly be granted piecemeal.
Yes, 2 weeks.
28, the Narendra Babu Dike.
I prefer complaint in this matter, please. 2 weeks time may kindly be granted.
Yes, it's 2 weeks.
29, the Encroachment.
Weeks.
30, the Adjournment.
2 weeks. Weeks time. All right. Please comply. Weeks time. 2 weeks. 1 week. 1 week.
31, the Rohit Swami. 32, the K.S. Narayan Swami.
What? Yes, madam. How much time? Each time. Could have complied, right? Please comply. Covered by judgment against you. Huh? Oh, huh? A week's time.
Number 33, the Rohan Kothari, government advocate.
What is it? Yes, madam. Oh, that late matter. Yes. Where are the officers, Mr.? Who is appearing? You are appearing, or Mr. Reddy? Oh, last time he appeared. All right. Yes, Mr. Reddy. Now tell us. So see, I mean, there can't be any dispute about the fact that the encroachment has to be removed, and we will ensure that it is removed. From what way? The last date of hearing, he only told us why these officers have come, because he told us we had granted 6 weeks time. He said that we have only sent letters, exchange of letters between departments, and you will agree that this will not help us anywhere, help anyone. So that's why we want your clients to make this thing statement before us within how much time they will take action to remove the encroachment. 1 acre and 7 guntas on Subramanyapura Lake, and 3 acres the other lakes. Yes. No, all this is recorded, right? I mean, this. What is the extent, etc. They all have told us. Yes. So what is the area of encroachment? No, Subramanyapura Lake. How much is the land under encroachment apart from this? Not slum. No. 1 acre and 7 guntas, right? That we have said that we have kept it apart, because that was the main argument, that lake is there, the slum is there, therefore nobody can touch it. This was the argument.
What is there?
Yeah, 1 minute. And what? How much is the encroachment in Begur Lake?
There are 3 types of encroachments in Begur Lake. One is encroachments by private persons.
No. How much? What is the extent of land?
About 5 acres, 1 gunta by private person. There are about 40 to 50 dwelling houses there.
Begur Lake is 5 acre.
5 acres, 1 gunta.
One. Yes. So what is your submission is that this is not encroachment, no encroachment on Subramanyapura.
It is approved by private person.
No, yeah, now we come to Subramanyapura first. So you say there is no encroachment.
I don't say that.
1
acre 7 guntas has been utilized and been there that road portion. Is been there for the times immemorial. The BKMP has done is only asphalted the road and tar it.
No, Mr. You should. No, this 1 acre and 7 guntas on Subramanyapura Lake.
It is only road. Yes.
So it's not an encroachment. No, but how do we see, Mr. You should see that compliance memo 11th of April 2022 filed by the state government. They have said it's an encroachment.
They said that possibly.
Nobody can construct a road on a tax area.
It was being used from times immemorial as a road only. It is not an enforcement in that sense. Nobody has put up any construction. And all that we say is this road has been there for a long time, very long time. We have come up and we are maintaining the road. And this has access to so many other places also. This road,
So what is road is not an encroachment.
no individual enforcement except for the road. And my submission is that it cannot amount to enforcement.
That's what we are trying to understand.
Yes.
So first your submission is that it's not an encroachment.
It's a road, I do say that.
No. What is the submission, Mr.
Submission is there is in existence a road there.
No, that's all right. The question is whether they because now the government and BPMP is at loggerheads, and we will have to adjudicate, right? So after they have come, this order was passed on 15th, 2nd of June 2022 in your presence. At that time, you did not say that it's not an encroachment, but now you are contending that it's not an encroachment, right?
Yes.
Not an encroachment. Not.
Under section 22, it may not amount to enforcement. That's my supposition.
No, but the direction is, Mr. Please, if you are interested in arguing that you see modification of that, then you will have to file an application. This matter has come up. If you are aware, probably that's the problem. That's the problem. Like that, the council, your council standing to your left side has argued on that day extensively. And this is what we have noticed in many cases, that one council argues, other one appears, and the other council who is appearing on the next day is not properly briefed. All these things, 2-6 or 2-6 and 15-7. This is all has been gone into. Now there is a direction that they have to state these officers. Please, you don't protect them. We have called them to tell them no. So therefore we have called them to tell us that within how much time they would remove the encroachment. Now therefore we cannot start it all over again, whether or not it's an encroachment, and to record a finding. And to record a finding that there is no encroachment. This is what it is. That it's a road and it's not an encroachment. That's what you are saying. So Mr. Please appreciate Mr. Manjul Reddy. We have there's no application for modification. 2 orders have been passed. The government says it's an encroachment. Now, at this point of time, we cannot go back and record a finding that there's no encroachment. Every land, Begur, just a minute, Begur Lake and this thing, everything is free of encroachment. Everybody is living happily. No.
In Begur Lake, I'm conceding that there are encroachments.
So then.
Your lordship directed me to go. Make submissions only with regard to Subramanya.
First, one by one. No, so they have to, this thing, we have said that the
government class has meant that this 1 acre 7 road is formed and road has been existed for a long time. It is an encroachment. Then it is an encroachment.
Why? It's an encroachment. They have said so. They have said so in memo dated 11th April. So, but, let us, we will hear you.
I should point out in that itself that the board has been there, and other than that, there are no private counsel, there are no either government utilities, no. These are not acceptable. If that road area is within the lake portion of it, lake area, then if it amounts to encroachment.
It is an encroachment. If in government has said so. No, the government has said so, Mister. We don't have any reason to disbelieve the version of the government. We don't know. We don't know what they should do. We don't. So,
The government also should take a holistic view of the matter. I still that from time to time it is my inspection at least.
so what happens to all right? We should not. What we feel is that every day we keep on. Just a minute. We should make some progress, right? Last time he said that slum board and this thing we have nothing to do. So I told him that no, that's just a minute. What we are trying last date also same this thing stand from your council standing to left. There was an obstruction. That slum board, I am not there. I can't do anything. We said you do whatever you can. Nobody will ask you to do the impossible. So we have kept that issue apart. Now today you have come up. That's not an encroachment. So what about Begur Lake? So then what are you? You tell us, Mr. These persons, ask them to come here. Don't I mean you please sit down, Mr. Reddy. They should not have the impression. After all, it's the question of majesty of this court. Don't protect them. Please sit down. Question of taking things lightly by them. You don't this thing. Come here, Mr. Whosoever is there. Who is in charge of Begur Lake? Madam, talk to him. Come here. Come here. Come from here. Stand here. Come. From here. Come on this side. In front of Mr. Reddy. Yes.
You remove that mask first. In ನಿಮ್ಮ ಹೆಸರೇನು ಏನಾಗಿದ್ದೀರಾ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಇಂಗ್ಲಿಷ್ ಬರುತ್ತಲ್ವಾ ಇದು ಏನ್ ಪ್ರೋಗ್ರೆಸ್ ಆಗಿದೆ ಏನ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀರಾ ಅನ್ನೋದನ್ನ ಹೇಳಿ
You are in charge of which lake?
ಯಾವುದು both Begur and Subram.
So what is the encroachment on the Begur Lake? No, how much is the to what an extent is the encroachment? We have been told by senior counsel that it's 5 acre and 1 guttas. What steps have you taken to remove encroachment? Last date of hearing, Mr. Counsel, hopefully you have told him what to do. What steps have you taken to remove encroachment? What action plan? No, this. So that was told to us on the last date of hearing. Before that, in month of June 2022, we had given 6 weeks time. So after 6 weeks and say about 7 weeks, you are coming up with this idea, brilliant idea that survey has to be done. What have you done? Who is your disciplinary authority? Who is the disciplinary authority of this person? Commissioner. Commissioner can place him under suspension. He can. Commissioner BBMP can place Chief Commissioner. Chief Commissioner can place him under suspension. So tell us why action should not be taken against you for non-compliance of the orders. What steps have you taken for removal of encroachment, except saying that survey has to be conducted? To detailed action plan to whom? To Mr. Reddy? When? Where is it?
It is filed yesterday.
Yeah. What is the action? Huh? Huh? No, last week also you were, Mr. Counsel, you told us last week survey has to be done. Same thing is repeating. And now is after 6 months, 7 months, 7 weeks, he's saying the same thing. No, like so time will start running from today. What did he do for 7 weeks? We want an explanation. This order was within his knowledge. 2nd of June 2022, we passed an order. What did he do? You tell us. We are asking the counsel. Yes. No, same thing, right? I mean, except Mr. See the predicament, please. I mean, we on that day also we told you that you have to act as an officer of the court and help the good cause, not to work as an this thing obstruction and this thing. We told you that day also. So what that point of time also you said that action plan. We granted you 6 weeks time. Thereafter a week's further time to come up with this timelines. So you are saying the same thing, right? Except as from 2nd of Mr. Reddy, you will appreciate being an officer of the court, not as a counsel for BPLP. That except that from 2nd of June 2022 till today, that is after 7 months, nothing, 7 weeks, nothing has changed except this affidavit. Everything remains on paper. 2nd June also, same thing, survey has to be conducted. Today also, survey has to be conducted. You suggest what should be done about this officer? Yes, we are going through what he has written. At least we should know what he has said. Yes. No. This whatever is timelines. He has given timelines of 3 months, 3.5 months. Yes. No, but nothing has been done except stating what I'm trying to say, our anguish, what we are trying to tell you is that nothing has changed from 2nd June till today except this timeline. When he is telling that he needs 3.5 months more. That's the problem. Nothing moves. The encroachment is still there. Not even a single encroachment is removed. Everything remains there. And he's 3 months, 3.5 months provision for time to file an appeal. He has to file an appeal. He is making a provision for, he has excluded that. Various state governments have been removing encroachments, right? Without notice. In some cases, without notice, and they have justified their action the Supreme Court has refused to state. How does it see? I mean, see the timelines, how unrealistic it is. See, please, whosoever has drafted this piece, second page. See, for conducting survey and physical marking of encroached portions, 30 days. Then it is again this conditional, subject to a deputation of required tehsildar. So it is always open for him to say after 3.5 months that tehsildar was not deputed, I can't do anything, right? So then again after survey, this is interesting, Mr. Reddy, please read. After survey, time required. Why? I mean, if the survey is conducted and they are identified, why does it take 30 days for the time?
Because survey itself is for that purpose.
So in the survey, the encroachers are identified.
This 30 days cannot be explained at all. This 30 days have to be excluded. But during the survey itself, you have identified.
So then we can understand that he says that 3 days I will, and we will see to it. This time limit also, this thing we will reduce. Survey can be done within 1 week. There is nothing. Tehsildar will remain this thing. Mr. No, he is relaxing. That's why we have asked him to stand up. They feel that we don't have, state government has no role in the matter. So that's why we asked him to stand up, and he is relaxing. So fine. Then don't disturb. No, there will be directions. Don't. No. And this thing, and Mr. We are fixing the timelines, and you tell them clearly that, and he should understand. I mean, that violation of any of these timelines, we are going to direct that either tehsildar will be suspended and disciplinary inquiry will be initiated against him, or this person will be suspension if it doesn't work. So next day we want this thing, the effect should be visible on the ground instead of filing compliance certificate. No. This.
So far as the Beirut Lake is concerned, Superpendipura Lake nurse your licensement. Kindly give some more time because it's a war.
Nobody can this thing, Mr. Wadsi. Yes, Mr. Government. Did you not say that it's not this thing? It's an encroachment. Then encroachment on nobody can construct a road on the lake. Can you construct a road on the lake in contravention of the directions of the Supreme Court that lake area there should be no encroachment?
Our survey and our history shows that this road has been there from time immemorial, even before it became part of the corporation area. This road was in existence.
So, Mr. This conducting survey and physical marking of encroached portion 1 week thereafter, within week thereafter, he should issue notices to encroachers, occupants, and we will post it after 2 weeks. No. No, it has to be done on a priority basis, Mr. This is like I was spending. No. See, Mr. This matter is coming up before us for past 6 months. Not a single encroachment has been removed. Not a single encroachment. And as an officer of the court, you will not appreciate this. That the ground level the situation remains as it is. These people are indifferent. You understand, right? Mr. If its survey is not carried out within 1 week, and if within 1 week thereafter you don't issue notices, you will be under deemed suspension. Right, 16th day onwards, you should treat yourself. You will not be entitled to salary. You should seek subsistence allowance from the commissioner, BPM, right? Deemed suspension. And you will have to appear again after 15 days and to tell us that this survey has been conducted, these encroachments have been identified. And thereafter, you have to, don't wait for this thing 30 days time. You are doing it, it is for the aggrieved person to approach the appellate forum. You are not sitting here for 30 days. And supposing what happens, if the period of limitation is not excluded, you will say that the condonation of delay can also be done. Why should you wait? You are removing encroachments under the directions of this court. The aggrieved person has to, and we are this thing, after service of notice, within 1 week, you will take action for removal. And the government will provide assistance, men and machinery, a police force. So all this has to be done within 3 weeks. If you don't comply, it's the encroachments are not removed, you will be under deemed suspension. Right? This is the order which we are going to pass. He will issue an order on that very day, 16th day. He will issue an order, Chief Commissioner, BBMP, placing you under suspension. If he doesn't issue an order, he will also be hauled up for contempt. Got it? One by one. One by one. We are road thing. You are constructing a road again, then you will say that it's time immemorial. so you will construct. His predicament is on the lighter way. His predicament is there. You say it will remain pending. No, this petition will remain pending for another 20 years. We will be gone. You will so you will still be there, and you will argue that it's time immemorial. So that's what he's afraid. So 1 minute. You have filed. We have granted him time to file applications, right? What did you do? Reply. What are you doing? Just a minute. Let him tell us what you tell us. What your grievance about the application? What is it? Yeah. Hey, one by one, right? One by one. What is your application? Which application? Which IA? What is 14 July? What is 14 July?
Point number 8, he says that there is a sewage line.
No, 1 minute. We don't have. What is the application? Which application is there, Mr. Reddy? Just a minute. This is 13 July, right? 14 July. What is it? What is it? No. What are they doing? No, who is constructing pathway? BBMP. No. Who is constructing pathway? Just a minute. Just one. BBMP is constructing pathway inside. Which lake? Pura Lake and Begur Lake. They are BBMP's constructing pathway. Inside lake means what? Within 75 meters. What is inside means what?
It is not provided for washing or something like that. It is only for the purpose of maintenance.
What is your existing affidavit? What is it? What? No, what we are trying to understand what affidavit you have filed. What is it? Direct to particularly to take. direct that notification. Prevailing condition. Affidavit annexure A. What is it? Living conditions of apartments. What is it?
The existing road. That's a very old road, and that was widened. My contention is around the north and west of the lake, inside the lake. I really heard, and the evidence of it I shall not be able to. Inside and outside.
There's already a road, right? This is the road.
That was the end of actually the car.
That's a different objection which is raising. We are now, let me answer one by one.
No, but let us understand his grievance. I mean, I really.
First, let me address this issue. With regard to pathways inside the lake. Pathways, according to him, pathways are being built inside the lake.
Where is it? Just. This is not lake, right?
Yes, this is lake. This is pathway. That is what he is saying. Figure 6. The green color is lake.
This one. This is the photograph.
This is a mud pathway.
Ah.
About 3 meters in width. Which is being provided only for the purpose of maintenance of the plant itself. Our officials are machinery will have to go there for the purposes of cleaning, removing of the scratch, removing of leaves, removing of so many things. It can't be done manually unless and until mud paths are provided, pathways are provided, which are very, very, very narrow here, measuring about 3 feet or 3 meters.
Not open to public use. Not open to public use.
No, not open to public. Second thing that is before to.
Where is your response to this, Mr. Natraj?
Yes, you're right.
Response. Okay, Mr. Natraj.
You find it.
Yesterday? Obviously, we won't get it. Yesterday, it has been filed.
Same thing, along with the other opportunities or license of the roads. One after
This is your reply.
Yes. In paragraph bottom, you have to some pipelines in the lake.
Which pipe?
Pathway created on the next page, pathway created regarding point number 10. Pathway created.
Want a pathway of 3 meters wide throughout the length and width of the lake. There's nothing but filling the.
1 minute.
For the purpose of maintaining it. In fact, this has been recommended also in this report. If I may kindly read permit you to read that.
Expert opinion on this.
See what they
3
say.
meter means, yes.
That's not open to the public. It is not concreted. It is not asphalted. It is not tarred. It is only for the purposes of maintenance. lake itself.
Want it throughout the circumference of the lake.
What is recommended also, that is what is recommended by the committee also. Proper maintenance and submit. This is a complete report which is provided for that. Very important.
We'll continue after the break.
Not for tomorrow. They come back at the
You tell us what you have to, you tell us now. Where is the report?
3:30 he will come back.
No, but we can't, I mean. No. We will take it up to date, sir. They all people, this thing, mister. We don't want to dilute. You will have to be here, mister. Whenever the case is. You stand here like that. Don't feel that it's over and all that. That action, we are hearing the counsel on other issues. That doesn't mean that it's everything is gone and you will go back happily and enjoy. Go for a movie. Don't do this. This order, qua you stands that you will be under deemed suspension. That order we will pass today itself in your presence. Right? So, what 3:30? Why 3:30? You tell us what is there, Mr. You tell us right away. So he can take over, right? What is who constitutes?
But they put only for the purposes of movement throughout the lake area. For the proper maintenance of the lake itself. Otherwise, that's if the vehicles don't move, supposing they cannot go to the church and stay beat out or especially it's already get far into the committee itself.
Which committee? Who constituted? Who constituted the committee? Which order? So that's why which petition, which order? WP 817 of which year?
This can be established almost the lake terrain. Beyond the high water mark, are close to the terrain and such ground level walkways will not obstruct the inflow of runoff water to the surrounding catchment area wherever the stream exists.
Hey, what is this report, Mr. Ware? No, but thereafter the Supreme Court has said something about lakes, right? Supreme Court has said something. This report is 2011, 11 years ago. Thereafter, Supreme Court has said something about lakes. And it's this thing 75 meters, no construction, nothing. But you are filling up the area of the lake by putting the mud and this thing. That's what we want to know, Mr. Reddy. Is it permitted under this thing? Under the we want to know. Please show us that decision and directions. Where is that Supreme Court? 3:30 will continue. 3:30. You be here. You please point out from the Supreme Court decision, right? Supreme Court has held, right, in and around the lakes, no construction within 75 meters. Yes. All right, so we'll continue. Give it. Where is it, Mr. Mohan? Give that. Yes. This monthly. Monthly. Give it, take it. It is kept. That he's giving some AI. On a hard copy, he's got. Imported this. Yes. We'll continue at 2:30. You said 2:30. You said just now 2:30, right? Yes. Yes, we will hear you. Don't, let him address. If we need your presence, we will just.
ಸರ್ ಇದು ಎಷ್ಟೇ ಅಲ್ರಿ
ಹಂಗೆ
ಹೌದು ಸರ್, ಬಹುತೇಕ ಹೌದು ಬರ್ತಾನೆ ಗೊತ್ತಿದೆ ಅಂತ ಬರ್ತಾನೆ ಸಾಮಾನ್ಯ ಆಯ್ತು.
Court officer. Court officer.
What comment that? Huh? So let them complete. We will hear you. I mean, no order. As it is, it will go for another hour. So there's nothing we will hear. Let him complete what he has to say. Huh?
What is being discussed is the buffer zone away from the territory of the lake. What is the meters to be placed? That is what is being discussed. Not on the pathway actually there is no prohibition, not there will be permission for construction of the pathway within the lake area. I don't know if you
No, no.
needs a reference.
Just a minute. There is a this thing. This judgment pertains to some like not to undertake construction within 35 meters of the lake area, right? Where is it? Which we want to do? Which paragraph? Para 60. Mantri, 6 zone. But it 60. State of Karnataka is agreed. Direct distance of water bodies. In case of lake, 75 meters from the periphery of water body. Buffer zone.
That's also in the buffer zone, not on the pathway within the lake area.
No, so like, I mean, what is the argument? Like 30 meters means within 5 meters you can do it, right? It applies only to 30 meters. What I mean,
We don't have direct relevance to the fact that the pathway is built within the lake for maintenance purposes.
no.
It's not even a construction that is being put up. It is a pathway which is a mud path, fully earthen, no construction whatsoever. It is only for the movement of men and material in order to ensure that we reach every corner and the lake area to ensure that it's cleaned up. There is a blockage of the inlets that has been here. Each of these places have been interactive. This means without the maintenance path, it will be very difficult to move men and material to the place where there is a construction level.
No, so see, Mr. 75 meters from the periphery of water body has to be maintained as buffer zone, right? So you mean to say that buffer zone you can do anything? Well, what is it?
In my case, it's relevant for land which falls outside the perimeter of the lake. Even if you include
No, so we will record your submission that you are in no way violating the directions contained in para 60, right? And if you do it, I mean, the consequences will ensue. So what is it? I mean, like 3 meters all around the lake. Why? For maintenance.
that is the required.
Machinery. How can you on a this thing on a mud this thing? How can you move a machine? So where all I mean like this all where is it with reference to this thing you tell us affidavit you have filed, right? You have filed a response to this. Where is it?
The response which is filed in the name of God is meeting on yesterday.
Affidavit. Yes. 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 Which is the affidavit? This affidavit. Which affidavit? Not here. Yes, yes. Yes.
Second page, I think point number 10 there. And point number 10. That concern is raised by the respondent. Concern raised the
Submitted that pathway is developed to facilitate. This is what you are reading.
Yes.
Pathway is developed to facilitate access. $3 now it is hyphen dash 4 meters. What does it mean? 3 meters, 4 meters. But you are arguing, you said, and senior counsel said in the first half, it's only 3 meters. Now we find 4 meters. That's why we are insisting for your affidavit. What else? So there's no question of road, right? It's a pathway. Don't be under a mistaken that you can construct a road on the lake and all this. This will not be. So where are you? Come here, Mr. We asked you to stand here. Huh? You started already flouting. The order is yet to be passed. Huh? Not serious about your future, right? In the PPLP. Not serious about your future. Yes. Where is that Begur Lake pathway? Not 30.
Below point number 13. Pathway is created within the lake area.
You are appearing for BPMP, right? So what is the response of Lake Development Authority on? Fine. So your submission is in sum and substance is that 3 meters of this thing mud pathway, no concrete, this thing, nothing will be, and it's only not open to public, only for the purpose of maintenance, so that you can move around and maintain the lake. This is it. And no other roads are being constructed. Yes, Mr.
December 17, 2019, we have produced the needy report in this case. Because the needy was appointed as the
17 December
19. That needy has suggested that the maintenance part, which is done on day to day, is essential for its survival.
Where is that report? 17 December 2019 is the report. I get it. If you have an extra copy, please pass it on.
The original capacity of the tank.
Mr. You
Section 12(6) of the Tank Conservation and Development Authority Act provides that prohibits construction of roads, bridges, and allied works within the tank area, including the tank bund. The authority may grant permission for such work only after ensuring that the original capacity of the tanks is not reduced even after such work. What? Yes. It's not, according to you, it's not going to reduce the capacity of the tank.
For that, anytime the mud which is used for formation pathway is the mud that we locate from the lake bed itself. Then when we take up the dredging activity, the same mud is used to form portion of the pathway. When there is greater depth of state in the lake, you have the water retaining capacity is not compromised nor is it reduced. It may increase.
Do you call it as desilting?
That mud is put as pathway for us to use it for manual machinery. It is not any mud which is got from outside.
Whether that lake is having any bund area on which you can do this activity for the purpose of preservation, whether that portion of the area could be used instead of having a new pathway.
It's not this pathway is not put up. Take the bund, I want to put it. Take the bund before touching the bund area.
Is outside the bund, not inside.
You have not stated so anywhere in your affidavit, right? You have not said so in anywhere in the affidavit, right?
But the photographs are otherwise. The photographs are otherwise.
Yes, Mr. Reddy, you should be here. So, according to you, what have we told that no roads are constructed in prohibition of law laid down by Supreme Court in monthly developers, whatever that decision. This is what he has said, that they are with this, you are not in any way violating the directions contained in para 60 of the judgment. This is the statement which he has made, which we have taken note of. And this maintenance path of 3 meters is outside the bund area. That is the another submission. And it is only for the purposes of maintenance of the lakes, and it is not open to public, and no permanent construction, but only a mud sort of a thing, pathway so that you can move around the lake and to maintain it, take out weed and all that. That's what has been told. That's what you were telling me. That's it. Lake Development Authority. Needy report. We is trying to find out. We will get it. So this is the report. You have an extra copy. He doesn't have. That's why he's taking out. He'll find out. Let him see what is it like. Who is the Lake Development Authority? Who appears? Huh? Who appears? Yes. Who is appearing? Lake Development Authority. Nobody appears. Who appears for the Lake Development Authority? You are appearing. Please come. Walk. Ask him to Mr. Come here. By his side. You should give company standing alone. Come here. That's inside. Come. Yes. Yes. He has to manage if he has not come. So we have spent about half an hour, more than half an hour on this, 1 hour nearly. You can't seek an adjournment at the fag end by appearing. So what do you say? You have heard? No, nothing today. I mean, you have heard what the counsel for BDA have said. Are you aware about the 2 lakes? Aware, right? So what are they doing? PTMP, what is it doing? What is the grievance of respondent number 8? You have been here, right? Madam, what is their stand with regard to whatever they have said? This 3-meter pathway inside the lake or something, what we understand.
ಅವರು 3 ಮೀಟರ್ ಪಾತ್ವೆ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಲೇಕ್ ಒಳಗಡೆ ಬರ್ತಾ ಇದೆಯಾ, ಹೊರಗಡೆ ಬರ್ತಾ ಇದೆಯಾ? ಇನ್ಸೈಡ್ ಲೇಕೇ ಇದೆ ಅದು. ಅವ್ರು ಹೇಳೋದು ಬಂಡನ್ನ ಆಚೆ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿ. That was the submission. Now he is saying this pathway is inside the lake. It is not outside the band. That is what he is saying. Yes.
So what is your stand? What is your stand on this thing? That it will be not open to public and this thing will be maintenance. What is your stand? Yes. What is your stand on this? Whether it's permissible in law? They are arguing that it's not open to public and they. But right. Pathway for so that you can walk.
For what purpose pathway is being made?
So that you can have an evening walk there, morning walk. They're constructing pathway for that, right? Public also is using it's constructed pathway. Said that public is using, people use it for evening and morning walk. What is this? He's saying people are utilizing for evening walk, morning walk. Did you not say, what? Who are you? What's your name? What? Who are you?
Speak loudly. Jorag matadi. License manager of lake.
So, is the senior counsel on instructions of chief engineer saying that nobody walks and nobody can walk? It's all mud. What basis you say that people walk inside the lake? Everything is serious, mister. We are don't time in. It's not an informal conversation, right? Where you can get away. This is a court of law. Whatever is being said here has a meaning. You are saying that on a this thing pathway which is full of mud, people walk inside the lake. This is the statement. We will ask you to file an affidavit if it is so. You will file an affidavit. People are walking on this thing at the risk of their lives, so that they can go inside.
Whether you are speaking about this particular lake or you are saying you are giving statement generally. Huh?
No, we are talking about Subramanyapura Lake and Begur Lake.
Yes.
Not. So who is aware? If you are not aware, who in the Lake Development Authority is aware?
Who is the responsible officer? Huh? No. He is from Lake Development Authority. Yes.
So he also doesn't know. So we are asking him who is aware, so that we can summon him. Counsel is not appearing. So this is what is the level of assistance? What can be done? Why you should be, constituted right here. This thing in this body should be abolished. This is the state of affairs that the Lake Development Authority, we are entertaining UPI for about 6-7 years for this preservation of lakes, and this is your assistance. So you don't know anything about these lakes. You have said. To be record, then why you should be there in the what's up with the report? What is it? Do you think what this case is going on for 1 hour, mister? You can't behave like this. So you don't know. We will record this. Get his date. Who is your disciplinary authority? Who will take action against you for suspension? You are a officer of the Lake Development Authority, and you do not know about Begur Lake and Subramanyapura Lake. This is your statement. So perhaps we should send this with a recommendation to your disciplinary authority to take action against you. Place you under suspension immediately. This is what is happening. You don't know anything. Yes, mister. What?
The pathways are actually built inside the lake. If you take the room as a lake, what it means is the legal limit is the wall. And we are inside the legal limit.
Yes.
And the no development from which is the Supreme Court.
No, mister. See, you must also be, you must behave sensibly, right? You cannot argue. You said that roads are being constructed. Now they have explained pathway. Now you have switched over to pathway. What happens? Yeah. Everybody is accountable, right? You cannot get away by making some statement. Please. Yes. So where are the roads being constructed? You told us that you have been telling us for 2 dates of hearing, and you have been asking us to pass an order. The roads are being constructed. They are saying no roads are being constructed. Only pathway for maintenance of lake is being constructed. This all affidavit. He has filed an affidavit. Now tell us where the road is being constructed. They are not constructing. Who is constructing?
Into the lake and they have moved the fences. And in addition to that, they have built a pathway within the lake limit.
No, with this, every time you cannot say something new and take them by surprising. This is the response. Filed to your affidavit. Point out from your affidavit or your IA, which you have been telling us for 2 dates that please pass an order. Where is it that IA or affidavit you have said that road is being constructed? constructed area has been widened, whatever, northern side, eastern side, where have you seen? Tell us. Where is it? Huh? 13 July. You got. So there are only 3 paragraphs. Read it first. No. First para is know the facts of the case bearing affidavit. Order dated being pleased to direct Brett Mangaluru to Bangalore to take applicable law to legally protect. Further, this court pleased to direct Section 30 officials file a report. I state as an humble effort to assist the court, I have undertaken assessment of state. Nothing. What report? You have not even said, Mr. in 3 paragraphs that some road is being constructed. Oh, this is 13. Show him. This is the affidavit. He is the person. Ask him whether he is the same person. No, you must see it. So 3 paragraphs. Where have you said? Even said in paragraph of the affidavit that some road is being constructed. No, this we are. This is your affidavit. But Mr. Singh, there are 3 paragraphs of the affidavit. No. The next page. 3 paragraphs of the affidavit. Paragraphs. What read it aloud. We want you to read it aloud.
Issued under Section 13 of our APCR, Litigation Official Located. I state that as a number of efforts is honorable court, I have undertaken an assessment of the state of the appropriate rate and the report on the prevailing condition as of date of the certificate.
The simple question is in 3 paragraphs, where have you even whispered that some construction is being made on the road on the tank? No ever made. No. You agree that in 3 paragraphs, no mention, right? No. This is called something, right? You have to put to the notice. Now they have said that we are not doing anything. You are arguing something else. You are not. You file an affidavit, right? There is no averment in your affidavit and you are making submissions, divorce. I mean, whatever you feel like. How this can go on? No. What detail level? You see, we asked upon them to file a response on your assumption that it is road is being constructed on lake. There is no mention in your application or affidavit that any road is being constructed. You will go scot-free. You will say tomorrow, you will say, I have never, sir, I have filed an affidavit. I have nowhere said. No. What? No. That's fine. But can you not say that, sir, I have not said anywhere in my affidavit that road is being constructed. We are putting them to notice, asking them to file reply on your oral submission, and now you are switching on to something else. Can you be once the simple thing is, Mr. Once the game has begun, can you change the goalpost like this? I mean, now you have given up that abandoned no road, nothing, and now you are arguing something else that it is inside this lake. What is this? No, Mr. Public interest litigation doesn't mean that you have license to do anything or to say anything in the court. This is a misconceived notion. So what is? So tell us, where is your grievance? No. Submission is what? You told us, Mr. You should be honest to yourself. You told us on the last 2 dates of hearing that my application is pending, sir. Please pass orders because we are constructing roads on the tank. We are finding that there is nothing in your affidavit. We will record this. That you have filed an affidavit without giving 3 paragraphs, nothing, and only you are submitting that they are constructing road. 5. What else?
So in addition to that,
So 1st July, have you said? 1st July. Have you said? Have you said? Where is it? 1st July, Mr. Have you said? Please read that relevant portion. What you have to say? Okay, Mr. Party in person. Listen to us. Mr. Respond number 8. There. What senior counsel has just a minute. Just a minute. You have heard counsel for BBLP. So what is your response on this? First July. Let him complete. We will hear. Yes. Yes.
Stage 11 from total year photograph. Figure 5 is a road expansion to the lake is
Paragraph 10. Page 11. Yes.
Figure 5 road expansion to the lake is located here.
Path being laid inside the lake. Road expansion into the lake.
The road was only here. Here.
Yes.
This is being expanded. It immediately with lake in. But the inspection no even to do the cheating. You are not trying to upload it just on this. We are kept silent. Now we are absolutely silent.
Widening of the road inside the existing lake areas will prohibit. Fine. All. Thank you. Yes, please. What is your response to this? Widening of the road inside the lake area where
Widening of the road inside the lake. That's my view. Both are illegal and both are no, or by the 8 months alone.
Not allowed. What you have to point out, simply saying not allowed.
Using the first June itself, in the affidavit, I mentioned that the road is being built inside the lake. I know the fences from the northern and western portion.
That they have denied this. There is no road is being constructed. No road is being constructed.
Inside the northern and western portion. That is my condition. So that is effective area of the lake has been drastically reduced by about 10 to 15 meters. Outside the lake, they are widening the existing road. Inside the lake, they are building the park. And therefore, the water holding capacity has come down. And they are deepening the lake so that the structure of the lake
Where is all this? Where is all this?
First June.
First June. Which paragraph? Paragraph 4.
Probably there is one of the major problem with the undergoing activity there.
Yes.
And the paragraph is exactly using the evidence of the date of the lake and its environment. There is a photograph that taken on the morning of 1st June, which are annexed to the next scenes. While on the one hand, the direction of the lake is indicating a vast lack of conformance with direction of the Honorable Court in Litigation 817 of 2012 and 4653 of 2012. Even that,
I want to get position.
Got it. Right.
In the interim matter, I'm going to submit the report corresponding to the undertaking widening of the road into the lake as it developed from the position.
Fine. So, where is the road being constructed?
On the northern and western portions.
No road, it's a pathway.
No construction. And inside
Mr. Please understand, we are prohibiting the widening of the road into the lake area. That is, we are passing in order. That is what we have said, asked you. What is your response to the submission made that it is not open? Just a minute, it is not open. Have you understood? Heard him, senior counsel. So he has told us that it's a mud pathway. It is meant for, it is not open to public use. It is only for the purposes of the staff of BBMP for who can enter for maintenance of the lake and weeding out of the lake and everything. To preserve the lake.
That is not about as per 8 months of the order. What is the pathway inside the lake for maintenance is absolutely not.
Where is that? That's what they are asking. Which this thing is prohibited. They have relied on this very report to say that it is permitted. Which page?
Your attention to page 13 of the report.
13. Yes.
This is under the section.
Which
Audit committee was set up by this wonderful report. And it gave a report, and in the final order issued on 11th April 2043, the entire report is read as part of the audit. It has been held as binding. And subsequently, the APC Act was enacted.
Mr. Where does it say that not permissible? Read from the report. Read from the report.
At page 13 of the report.
Huh?
Page 13 of the report.
We have taken out.
Just
What
read
is
it, read it.
Oh, you don't have the copy, right? So read it, whatever, which.
I watermark instead of jogging flag. So we kindly mark I watermark. I watermark is defined as that watermark which the maximum level of the water is defined as the legal limit of the lake.
Where you are reading?
Page 13 of the report.
There are para 2, 3, and 4 in page 13, right?
Report has given us a copy. Extract.
The entire report is I'm sorry, it is page 11.
Page 11.
Walkways above.
Walkways above, I watermark instead of jogging. I want to submit to worship that I watermark as the understood here as the maximum considered twice. When the lake reaches the full, all our tropical lakes are none of them are meant for water.
No, but please understand, it's not a walkway, not to you meant for public in general. Nobody can walk, have a morning walk, evening walk, not like this.
This tradition goes back 6,000 years to our times, and from then till now, there is no need for any mud inside for maintenance. Because even the lake,
No, we are asking. You said that law does not permit, so we are asking which law, where you refer to the report. Report. You are done with this report.
No, I just finished this report. So this is the report which went into the details of the ongoing activity of lake rehabilitation at that time. It was 11 years ago. And this is starting over all the 9 departments which are connected to the matter. And all the heads of 9 departments, the members of this committee are agreed to this, including the chief commissioner of BBM. And then together along with this.
No, nobody is disputing this. We are asking you only to point out which part of the report prohibits maintenance. Walkway.
Walkways of I watermark instead of jogging tracks. Instead of being dedicated jogging tracks, the path marked cobblestone ground level walkway
can be developed with a width not exceeding 3 meters. This can be established off around the lake perimeter, not inside the lake.
Beyond the high water.
Beyond the high water mark, not within the high water, or close to the perimeter. It can be outside, just outside the lake in the water development zone, 30 meters, but it cannot be inside. What we are doing is building it inside. This is one part. The other part of the high water adoption is that there are 7 pieces of page 14. Effective weight area should not be converting weight area to blocks, shouldn't be blocks, right and bounds, etc. The de-risking has to be minimized to remove only large portion is minimum that we have foreshore. Foreshore is that part of the lake where water comes in to fall around. The lake is basically a structure where the fund is to get from the stream or a nala or a valley. And thousands of such lakes are built. And all of them are interlinked. The present saucer shape de-risking should be given up as it is cost prohibitive and leads to huge fund making and creating storage capacity beyond the lake. There are two reasons about it. One is sometimes the deeper the depth so much that there is water beyond the capacity of the lake, and there is a technical committee report where people have lost houses because the water present when heavy rainfall will break the embankment and flood downstream. So that is not allowed. Secondly, reduce the water storage is also not allowed. Proper shape deepening of lakes where in effect the wetland formation is also deepening of the lake. It is essential to filter the water together and important from an ecological point of view. Exception to this can be restoration of lakes with adequate anticipated important in rainy season, where deepening is necessary, keeping in view impounding more water to recharge depleting groundwater and to mitigate flash. Take care of both depleting water level as well as flash flood. And in section 2 of the KPC, I can rely on that.
Section
2 of the KPC.
and contempt.
What is a lake or a pond or a tank is different. These are terms which are interchangeable. We used to call them irrigation tanks, now we call them lakes. In an inland water body, we will be sure whether it contains water or not. Because as I explained before, they may contain water, but many times they are not. And that doesn't mean it can be abused. But mentioned in regular of the Sarkari case, Yara case, Dunke, or any other field, and includes the peripheral catchment area, including the Raja Kavi. If the Raja Kavi are not protected, then the lake dies. And the next lake has water. And upstream gets flooded, and in a flash flood, many houses can collapse. Lake people inland and other inlets, once Bureau uses grab outlets and main channels for drainages to and flow, but does not include plants which are more than 2,000 acres. There is also section 3.
So your concern is that the road should not be constructed inside the lake area.
In the nature of one or the nature of
wait, you say that even that can't be done.
Yeah, it is not necessary.
So how so can any idea, you since you are an expert, any idea? No, so how will the weed be removed? How will the lake be maintained? How it will, if there is no access to the lake and everybody has to stand out, then how it will be? Any idea on this?
Any working tool, it's just like paint is outside.
No. How the weed will be removed if nobody can enter the lake area? How it will be removed? So we want to, because we are not experts. We have no idea how to clean. That's why we are asking for your suggestion. How it can be done then? If nobody can enter, then how it will be done? How it will be weed, etc. How it will be cleaned lake, supposing, and weed will be removed. How it will be done? Oh.
So one enters from anywhere in the world, all around the world. And yes, excavation is required. It is only that much in which the water has to be not too deep. Because if you see the other thing that I have justified, that God has given us
creating so much important that we destabilize the way. That's what their justification for having built the road inside, because they are not disturbing the water body in the past. But that is a problem. When you build a lake beyond its natural range, then the one will work. It will not happen like that in 5 years. And people downstream will be it. Which is why the lakes have to be held in accordance with the watershed plan, not just because it's a stage where we go. And the coastal area is very critical to worship. Both from the ecological point of view, we have seen a drop of almost 80% of the bird life, which is why the early 90s. For instance, in Devon Lake, I have seen about 20,000 birds.
Yeah, we know we are on the right. We are on the construction of routes at this point of time.
Yes, and then we think the problem.
We think we have devoted more than an hour for this case. You are not satisfied. So your grievance is heard today, right? That's all. Anything else will come to birds will be there, right? Next date of hearing will come to birds. First, the lake has to be preserved, then birds. Yeah. Yes.
Critical for the birds to survive. It will destroy the habitat of birds, especially migratory birds, which come as far away from Siberia, Mongolia, and Asia. When they come here, they don't want to get back. There are all the lakes are being developed. I have been approaching Mr. Mohan Krishna for 6 years now. Explaining him, I will give my assistance team. Dr. Subramaniam, who is the leading author from the Bombay National History Society, has come before the government of court, but they don't take our assistance. We don't want a single rupee from the people. I have returned to the Chief Commissioner. So my point is very simple. Please look at the Justice Department Committee report. Follow it. Everything is written down there. Even the designs have been provided. And if that can be complied with, this almost 11 years ago in the report.
You have seen, Mr. How in 11 years, not even a single encroachment has been removed on the lake. You have seen, right? Now that's why these people are in the dock, right? That's why we have to, not even a single encroachment, this all birds and this thing, this is good, right? Talking about birds and all that. No, what we are trying to tell you is the practical difficulty. You see, why we have kept him here? To emphasize, to emphasize the need of removal of encroachment, right? They are not doing anything. You rightly said 11 years, nothing is done. Nothing is visible. Not even a single encroachment has been removed. That is. So nothing has happened. That's what.
There is a department which has come inside the lake, you don't have that concern. And that is observed in these directions.
Yes, sir. Needy report. Mr. Where is needy report? Extra. Yes, please. Yes.
Very matter in the report. This report submitted based on the article 23. Your opinion of the side are really and better responded to
Page 12.
Page 1.
Views. What did you say, 14%? What? His opinion. 8. Yes.
Same gentleman was also referred.
Yes.
No, I'm 50. The following government activities have been taken up and it will be since July 2018. Second point, what we have done. What we have done. What we have done has been constructed around the lake will be the material from the lake. needy is trying to go to page 3.3. Bullet point 1. All government activities undertaken by look at the lake. Is there a justification? How to different chemical materials are preferred, etc. That is bullet point. Actual lake area. However, yes, it does not contain natural underground water.
No, so this walkway bund has already been made. So what are you doing?
No, no, the same water we invested the improvement in the lake and the things like that, other lakes also. This is the respect of Lakewood Lake. We are not making any investment of Lakewood Lake. It's already there.
Oh, this report pertains to lake. And you are trying to do it in respect of Subramanyapura.
Similar developmental activity.
Subramanyapura lake. This walkway bund.
Yes. Yes.
Without compromising whatever is the using the desilted material from the lake.
Yes.
You won't bring anything like.
It's a multi. That's why we I don't know if it's not not open for the maintenance. The two orders also.
This report was called for in pursuance of which order? 79 or 30?
Order dated 18/6/2019.
18/6.
2019. The watches will find that on page 11. First page of the report.
Page 11.
Secretary number so dated 18/6/2019.
Yeah.
The letter written by the needy to the commissioner's meeting to the extent of the so he was required to deposit the amount to the meeting. Government is not accept therefore so directly.
But will Mr. Whiting will prohibit that? Yes. No. Yes. Just a minute. Oh, now it's your turn. Yes. Who appears for the petitioner? What's your name, madam? What is your name? Huh? Yes. So, one part of the order listed for the benefit, your benefit, we are telling for everybody's listing for information. Then we'll continue. Just a minute. Huh? No, we are dealing with two issues today. First one is that this officer who has given, we have devised the distinct timelines that we will tell you. And second is with regard to construction of road, right? Let us. Huh?
What is state government?
They have made a statement that they are in no way violating the directions contained in para. We are recording this.
It will be 30 meters, although it is not have to be what you
We are not saying 35, 70, whatever is so said by Supreme Court, if 30 meters, let it. It's nobody's case, Mr. They are not doing it. Oh, you have to tell us who is raising construction. BBMP says they are not doing it, right? So then, who is concerned? Who will tell us? I mean, it's nobody's case. I mean, he even this respond number 8 did not tell that anybody is raising construction. What?
government has to say, because they have to do the survey.
No, but there has to be a material, right? I mean, we cannot do directions in vacuum. It's nobody's case. I mean, that we can't presume that construction is. Please appreciate. Please, that's why who is doing it? Please, like he said that they are constructing the roads. So we have. Very difficult, right? Yeah, please understand our predicament. It's going on for 8 years now. Every time. For, huh? Huh? So,
in which I said it is a pathway or road or whatever they call it, it should not be inside. You can call it whatever. But I'm saying it should not be inside.
That we will deal.
These observation by this court about the import of its findings. On 5/3/2021, the Honorable Court had made of that order.
What? That report of need is wrong. Huh?
Needy's report be taken into account.
5/3/21. No, I mean, Needy is an expert on the subject. They have.
In terms of environmental engineering, not ecological aspects. It is an environmental engineering part. On the structure of the lake in terms of engineering. But it's a living system.
So you suggest, Mr. You are an expert ecosystem and all that. Give your recommendation, suggestion. Give it. No. So we are dealing, as we told counsel for the petitioner, that we are dealing with two issues today, right? We cannot continue for 30 hours and decide everything else and retire. We will be happy to do it. That there should be no encroachment on the lake, etc. General directions, and your recommendation we will make part and dispose of the petition. Will you get anything? We are dealing, Mr. Please, Mr. Appreciate. I mean, you should appreciate that something needs to be implemented. Not even after 8 years, whatever you have argued, 3 rounds, 4 rounds, recommendation, not even a single encroachment on the ground has been removed. The ideas is good, right? You suggest, we will write everything. You give a writing, whatever you have to.
That is my contention. And that worries me deeply because it's not in the court very clearly in earlier orders as well. In fact, on 5/3/2021, this order reports, if I may read that part.
There is no point in reading orders which have not resulted in any action. We are moving forward, right? These two persons are why they are standing. Because 5/3/21. What is it? 5/3/21. It be more than 1 year and 7-8 months have passed. That's what we are. That is what we have told Mr. Majnun Reddy, that in 6 months nothing has happened except passing direction. You want us to pass some long order? Give your submissions, right? In writing. We will incorporate in the order. We don't know if you are happy. So what is? Where is the written submission? So you don't want a removal of encroachment. You want your written submission. So that's what we are trying to do, Mr. No, we don't know whether you are You want removal or not? Because you are written submission. We are holding them, making them stand for, these officers are standing for 1.5 hours. What for? Because we are serious about removal of encroachment. You want to dilute it by written submissions. What can we do, Mr.? If you are, no, we will pass a long order of 20 pages, which will not result any action on the ground. If you want it, give it. Let them relax. Why they should stand here? We'll argue. We will decide about birds when it comes. Migratory. It will be interesting reading. Which bird comes when we don't really know. It will really enlighten us on birds. No. So tell us. We don't want to go to lake. You tell us which bird comes, which. So show us photographs. Which bird comes? Let's decide that. You relax. You sit down. We are talking about birds. Which bird comes when? What is which bird? What is the bird which comes? Which single?
You allow the lords to pass orders.
No. And what is the report? Sir, we have told Mr. Mohan that, and Mr. Raju Reddy, how many times? Every time so many lawyers are sitting, every time we should tell that we are dealing with two issues: removal of encroachment today, and today we are dealing with, after devoting 2 hours nearly, and you want to talk about birds. You don't want removal of encroachment. Let's talk about birds. Which bird comes when? Fine, interesting. Show us photographs. No. Show us photographs. Which bird comes in October? Which bird comes in November? What happens? Show us. Prepare this thing. We will arrange for a projector here. Why don't you make a movie on migratory birds? So the best way to deal with this public interest litigation. Rangatittu, yes, bird, but yes. Rangatittu, what? Yes. Sir, tell us.
We can have that discussion on the next date.
Do you ever realize, Mr. that 8 years you are standing there only, arguing about recommendations? There is a need to translate the ideas into action. And this is what we are trying to do by, you are diluting the effect of this. The result is they were standing here. They happily went away and sat down. They are relaxing. This is the effect of birds. You are diluting they were standing here. We were trying to convey that it's a must to obey the orders. You have diluted the whole seriousness of the proceeding by talking about birds and expert report. Do whatever. What is your report? Let's see what report you have submitted. Okay, what is your report? We'll discuss about it. What is it? Report.
My approach is to remove the encroachments and restore the beds which originally were the and all I'm submitting is.
No. So what are we trying to? No. So what order has been passed by this court on the last 2 dates? Why that person has been directed to appear? Why? We want that it should be encroached, right? That's why he's called here. That's why to facilitate encroachment, that designator. There's no question of this. All this, Mr. You should understand. All these things one by one we have to be. Presently, everything can't be done. We can't take care of birds and removal of encroachment simultaneously. Some issues have to be given priority. According to us, since you flagged the issue of that construction, we have adverted to this and we are deciding it today. We are dealing with encroachment. So what about now? You want birds also? You want expert opinion also? What is it? You tell us. Tell us what is it? Expert, what is the recommendation, your recommendation? What should we do? Nobody is arguing that they should be allowed to destroy the lake. Nobody, Mr. Nanjun Reddy has not argued, nobody has argued. They've given an undertaking. They've stated that they are being raised. What is, how much time can we spend on this litigation at the litigants? 2 hours we have spent. Still you are not happy. Perhaps you should go somewhere else. Really? What can we do? We are doing our best. Report. What is the expert recommendation? What is it you are referring to? Let us see. No, what is it? What do you want us to do today? That report. No. So they have not disputed Justice N.K. Patil's committee report. They have not argued that it's not binding on us. Nobody has argued. So where is the? So what do you want us to do? Tell us. Not to remove encroachment at any cost, right? We should not pass an order directing removal of encroachment.
This was from 2013. If I was not concerned about encroachment.
Tell us, you argue, we are waiting for you. Everybody is waiting, whole this thing. Say whatever you want to say. Please. You raised an issue of construction of roads. We are deciding it. What else? If you permit us, then we will pass an order. Otherwise, we will hear you. We will be happy to hear you for another 45 minutes. Go ahead without passing any order.
Today on those two issues, orders will be passed. Stop your argument. Allow His Lordship to dictate. Reserve your argument for the next hearing regarding birds and other things.
Yes. So, Mr. Reddy, so we have taken into account this, whatever has been stated. Call them. Oh.
You come to both of you.
Yes, come here. Yes, stand here. Yes, call. What we have said is we have taken note of whatever timelines he has stated in the affidavit. We have said that this petition is pending since 2014. Therefore, it can't prove any delay. The encroachment still exists. So therefore, we have recorded a statement that concerned tehsildars shall abide by the directions which may be issued by this court, and men and machinery would be made available to the designated officer for removal of encroachment without any delay. Right? You can't run away from your duty. No. So they are banking upon you, right? So therefore, we have said that you have assured this court. We are putting you to notice. Then don't say, I did not know. Then the directions which are issued are survey and physical marking of the encroached portion of the lake shall be made within 10 days. Tehsildar and surveyor shall be deputed by the state government for the aforesaid purpose immediately. So the survey notice shall be issued to the encroachers 1 week, Mr. The men and machinery shall be provided to the designated officer within a period of 3 days thereafter, and encroachment shall be removed within a period of 1 week thereafter. These are the timelines, and compliance report shall be filed on in this regard. Right? All this, you need not wait for them to 30 days and all. Yes, 10 days. 1 week. How does it? 10 days. All right. 10 days. The compliance report you have to file. Right? Tell him this. Line below, compliance report shall be filed after this. Huh? Any huh?
Another 3 months after that are replacement. But that will not publish. It will not burn.
No. Don't I mean that's what he is doing 3.5 months. You don't extend gradually. These are the directions. Do it. Mr. 2014, 7 years have passed. Be serious about it. Don't I mean
Whether
you are an
you're
officer
seeking
of the
extension
court.
of time or what?
Extension of time. Huh? That's what we. No, why not? We should grant you 6 months time to Tehsildar. No. Mister, you being an officer of the court, please convey the sense of urgency to the officers. It does not book any delay, right? 7, 8 years have passed. Not even again we are required to tell you.
I don't think
No,
he's
we
seeking
have dealt
extension.
with that party in person. Now it's your turn. Again, all over again. We should start from A, B, C, D. Huh? No. Don't do it.
Whether you are
Don't-
seeking extension of time, no. What you are saying, what he is saying is already.
Do it. You are welcome. We don't know. Whatever is the.
Yes.
All right.
In addition,
So what have officers? How many tehsildars have been provided already?
three more tahsildars should be provided. That is what he is saying. In
Without
addition
any
to-
delay, you have written. Yeah. 1 minute.
Wait.
1 minute. Here. Learned additional government advocate further submits that Tehsildar, you tell
in
this
addition
person
to the
doesn't know.
Bangalore South Tahsildar.
No. This officer, designated officer doesn't know. He is telling us that it is subject to providing Tehsildar. You say already provided. You tell this person, Mr. Tehsildar has already been provided.
That is jurisdiction Tahsildar of Bangalore
No.
South. Yes.
You know, we are asking you. That's what we are saying. You are making, see,
Bangalore
Mr.
South
Comment.
Tahsildar is there, you know. Already Bangalore South Tahsildar is there.
he has to implement that. We have understood, madam.
Yes.
He doesn't know. Implement.
Yes.
He doesn't know. Mr. Ash, what is this communication gap? He is standing just 3 feet away from you, doesn't know. You are saying that we are throwing 4 tehsildars on your head. He doesn't know.
Bangalore South Tahsildar idarenappa. Yes, it is all.
Hey,
And
so
then in addition to that, 3 more they are going to do.
what this thing is. We have told you, be happy, you depute 50 tehsildars. There is no prohibition in this order that you cannot depute 100 tehsildars. No prohibition. Do it. But tell them that any deviation from these timelines not complied with will result to we are writing that. He has already been told that these officers will be under due suspension after the expiry of timelines. Tehsildars will also, we will ask secretary authority to place them under suspension in case they do not cooperate with this person. Got it, Mr. Be ready for subsistence allowance. Yes. Of course, men and machinery includes police protection. Yeah, all right, including police protection. Obviously. Smiling white not intending to comply, right? Already thinking of something else. What to do next? He's smiling. That's why. Do it, no? That's what is expected from the government machinery. This thing, public issue like that, which involves public in general, right? It's a litigation for future of Bangalore and for this city, future generation. The compliance report shall be filed in this regard. Then it is made clear continuation, right? In this regard, line below, it is made clear that that if the timelines mentioned in aforementioned timelines are not adhered to by the concerned officers, this court shall be constrained to pass appropriate orders against the aforesaid officers, right? Aforesaid officers, paragraph. At this stage, party in person, namely respondent number 8, has invited the attention of this court to the affidavit dated 1/7/2022 and 8/7/2022. 1/6/22 and 8/7. What is it? 14/7/2022 and has pointed out that the construction of roads is being made inside Subramanyapura Lake and Begur Lake. Stop. In response, learned senior counsel for respondent number 4 submits that BBMP, which is a public body, is bound to abide by the directions of the Supreme Court in Mantri Tech Zone P Limited versus Forward Foundation 2019 (18 SCC 494), as well as a report submitted by Justice N.K. Patil Committee. It is further submitted that a walkway along the periphery of the lake consisting of mud has already been is already in use in Begur Lake, and the same is being constructed in Subramanyapura Lake with a view to maintain the lake. It is also pointed out that the aforesaid pathway is not open to the use of public in general. Learned senior counsel on instructions from Mr. Who is this officer? Mr. Mohan Krishna, Chief Engineer Lakes, who is present before this court, submits that the
Been constructed in Subramanya Lake with a view to maintain lake. It is also pointed out that the aforesaid pathway is not open to the use of public in general. Senior counsel
and is meant to facilitate maintenance of lake, right? Lakes. It is learned senior counsel on instructions also has further submitted that no roads are being constructed within the lake area, namely Subramanyapura and Begur lakes, right? No roads are being constructed, right? You are not constructing any, has not undertaken construction of any new road. Right. We have considered the submissions made by learned senior counsel for the petition, learned senior counsel for respondent number 4, in compliance of the order dated 18/6/2019, needy. What's the
Needy report.
EB? What is needy? Needy. An expert body was directed to submit a report. Full stop. The aforesaid expert body, after inspection of the lake, has stated that BBMP since July 2018 has undertaken the work of dewatering, desilting, and deweeding. It has also been stated in the aforesaid report that formation of walkway one has been constructed around the lake during using the desilted material from the lake. It has also been stated, full stop, paragraph. Therefore, we do not find, like line paragraph, we do not find any ground not to accept the opinion of an expert body. From the perusal of the report, aforesaid report, it is evident that walkway one is already in existence in Begu Lake. To stop the BBMP is therefore permitted to construct a bund around the lake, measuring 3 meters in width using the desilted material from the lake. It is also made clear that no construction. It is also made clear that no cement, etc., shall be used for the purposes of walkway bund. It is also directed that the aforesaid walkway bund shall strictly be used by BBLP for the purposes of maintenance of the lake, desilting and de-weeding, etc. It is further directed that the existing roads which are situated within the lake area shall not be widened, and yes.
Page 11. Yes.
We are saying existing road shall not be. No, we are directing existing roads shall not be widened. No, we have not said anything about it. We have not recorded any concession. We have only said that you are saying that walkway and no construction of roads is being made.
Is contrary to this. It is falling within the lake area.
No, we have said existing roads shall not be widened. It's an order, not on your concession. We have not recorded anything.
It is already extended.
We are saying that it should not be widened, right? I mean, we have prohibited by way of an order, not depending on your concession in any way. These are directions. That's why we have said no existing road shall not be widened in this.
Otherwise, they will continue.
Not continue. They can't. We are passing an order. They can't continue. It will be contempt. No, but what's the? I mean, we have issued a direction, Mr. We have issued a direction. All right. So what?
It is further
Which
directed.
lake? What is it? His submission, right? His submission last learned senior counsel for respondent number 4 submitted submitted that submitted with reference to first photograph appearing at page number 11 of affidavit dated 13th of July 2022, filed by respondent number 8, that the work of proposed expansion of the road may fall
Even
within the lake
asphalted road
area.
also, asphalted road also, that the extent.
That the work of proposed widening of the road may fall within the lake area. All right. We have already prevented. We are not different. So,
Prohibited from,
no, all widening, not only this. All
otherwise they will continue with asphalt.
It is further directed that existing roads which are situated within the lake area shall not be widened.
They will be prohibited from.
walkway, right? Where have you said about walkway?
Walk and any ground in not to accept the report expert body from the perusal of the aforesaid report. Walkway is already in existence in Begur Lake. The BBMP is therefore permitted to construct the area lake measuring the 3 meters.
Walkway. Permitted to construct a walkway.
Construct walkway area.
Bund area.
Bund area. Lake measuring the 3
Bund area of the lake measuring 3 meters.
And desilting from the lake.
Desilted material.
Silted material from the lake. It is also made clear that
it is also made clear
that no cement, etc., shall be used for the purpose of walkway.
No construction material except mud. Delete. No construction material except mud shall be used. So stop there. After you write, it is further directed that the BBMP shall ensure that walkway bund shall be properly made without compromising the actual lake area. Right? According to whatever is. So, I mean, all we have given the let the petition be listed after 6 weeks. What? They require some time to develop it. 33.4. Oh yes, it appears Mr. Reddy has not been instructed in that case. One case at a time, right? What? Which 33.4? 30.4. It will come up after 6 weeks. You want to file this thing, something you file? Let them. Respond. Which 33.4? Yes, which pertains to which lake? What is it, Mr. What is it? The affidavit you have filed today? Who is the Which
They want time, they don't have funds. No, once they get the funds, they-
funds?
They are given the response.
Yes, next it. All everything order, right? Clarification.
The one relating to cleaning the area around the base. For cleaning and
Who are you?
I'm repeating application for now, this one number, the other.
No. You can't be granted any relief in this PIL, right? If you have a separate cause of action, file a petition, do whatever, file a suit, do whatever you want. So in a public, like what we have noticed is that very frequently people file a pleading application in the public interest litigation and seek an independent relief. That can't be. Do it, whatever. It has nothing to do. It is, see, Mr. This petition essentially pertains to removal of encroachment and birds and construction of roads and birds. Next season, we will see how many migratory birds come to the lake, right? Number should increase. Best indicator, yes. So this is, if you want to clean it, please clean. Nobody prevents. BPMP is preventing you from cleaning.
On 4th March 2020, this on 4th March, in order that the BPAP should not.
You write this thing. One sentence. What's your name, Mr.? No, not this officer. Designate. Mr. Pramod Kumar, so and so executive designated officer of so and so lake shall remain present on the next date of hearing. Then give a date. 6 weeks. What is the date? Just a minute. We will giving it date. You have to remain present before the court, Mr. Along with the report. And it should positively, you should otherwise, you will get your order of suspension from here only. You remember that. September. 1st September. List on 1st September 12. You will have to appear. Yes.
6
what
weeks
is the-
early ಆಗಿದೆ. Correct.
4th March 2020, this on the court had passed an election. We entered into contact with private cooperative entities.
You are private cooperative entities. Then
So that order.
you are this thing.
I am a
Who are you? You are an individual like NGO.
Yes.
NGO. See, like respondent number 8. An expert.
Who are simply cleaning the side of the lake. The lake itself. The MOU were executed on an annual.
No, we'll clarify that this thing, the orders or the subject matter of this petition does not in any manner prevent prohibit anyone from cleaning the lake, right?
These are MOUs, produced MOUs, whereby I am maintaining the area around the lake. The BPAP is.
No, that means maintaining means you are cleaning the lake. So please clean. That's what we are.
The area around the lake, you don't touch the water. The pathways, the areas around the lake.
Yeah, but you say all of you are meant to argue only. Nobody does any groundwork, right? You just go around the lake and see anything and note it down and come here and argue. You do something. You are a resident, you will do it. No, but why this courts? We don't. No. Why do we? Just one minute, one by one. So why do you need the court's permission? No, which law says that without permission of the High Court you cannot clean? Which order prohibits you? Tell us. Which order? 4th March prohibits you from cleaning. No, let us understand. You are a resident welfare association, right? Residing where? I mean, where association is on the bank of the lake. Which lake? No. We are don't expand. We are dealing with Begur Lake and Subramanyapura for the moment. No, so what is it? So you clean the lake. Huh? Nobody, which you for cleaning the lake, you need whose permission? Definitely not High Court's permission. High Court does not grant any permission for you to do anything. We will clarify that the orders passed by this court does not prevent anybody from cleaning the lake in accordance with law. Fine. Yes, Mr. Reddy. MOU, what is it? Ah. 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 No, that means they will enter the bund area and will walk there, right? This is what. That's what is cleaning. You are permitting them to clean the lake. That means you are permitting private individuals to appear in the lake. No. Meeting means again they will have to enter, right? They will say that we have authority to enter the thing. This thing you have just pathway you are creating. They will, all of them will enter. Who will prevent? No. No. All this is outside, Mr. If you want to enforce your right arising out of the contract, if there is a breach of contract, file a suit for damages. No. No. There's no. Where is the bar? That's what we are asking.
5-3. 4-3-20.
Private entity. Now, PLP is interpreting corporate entities to mean even resident welfare association.
When?
One of the order. For 3-20-20.
No, let it be the old days. This dedicated to lakes, so let it be. And what can we do in 5 minutes? Don't feel this thing. No, fine. We'll take it. Don't.
Natras 4-3-20.
Now. Which petition? So you are also supporting him, right? And so go there, stand by his side, so that I mean, if you hear stand by the side of, please go there. Don't join Mr. Mohan. He will not spare you. Yes. No, Mr. P. One.
Such MOU should not be. Our MOUs are of a completely different nature. Those MOUs were the corporate entities which you do that as CSR and used to advertise, etc. The Honorable Court has said that is not permitted. Even to that, the BPMP has written to us saying we cannot renew these MOUs because of this order. Therefore, we are unable to renew.
What is your MOU? What is your MOU?
My MOU I have produced. If I may just read out what my.
No, tell us. Go through it. What is it?
ಆಫೀಸ್ ಫಸ್ಟ್ ಇಲ್ವಲ್ರಿ ಅಲ್ಲಿ ಇಲ್ಲ ಮೇಡಮ್ ಅಲ್ಲಿ ಇದ್ರೆ ನೋಡ್ರಿ ಅವ್ರು ಯಾರು ಇಸ್ಕೊತಿಲ್ಲ ಅಲ್ಲಿ ಇಲ್ಲೇ ಇರ್ತದೆ ಗಜೇಂದ್ರ ಅಂತ ಗೊತ್ತಾಯ್ತು ಇಲ್ಲೇ ಇರ್ತದೆ ಸರ್ ಒರಿಜಿನಲ್ ಬೇಕಾದ ಇಲ್ಲ ಜೆರಾಕ್ಸ್ ಕೊಡಿ ಒರಿಜಿನಲ್ ಬೇಕಾದ್ರೆ ಸರ್ ಕಡೆಯಿಂದ ಹೇಳಿಸ್ತೀನಿ ಏನು ಒರಿಜಿನಲ್ ಇದೆ ಎಲ್ಲ ಹಾಸ್ಪಿಟಲ್ ಅದು
There is no order.
4-3-20.
4 March 2020. As of 2009.
3rd March. Hey, Mr. You.
4th March.
Order. March, you point out. There is an order 3rd and 6th March. There is no 4th March order.
Totally. 2020.
PC. He has been mentioning this IA last date also, he said. No.
I think a manager can take the instruction, let them take instruction. Because on this matter, I don't think there is any contention on.
What is your IA? Some IA?
5, 6, and 7.
5, 6, and 7 of which year? All right. Write down there before list, on so and so. Before that, you are appealing for which respondent in which petition? Counsel for learned senior counsel for AP praise warrant is granted. Time to enable it to seek instructions on IA 5, 6, and 7 or 2022, all 22. Response to IA number so and so filed on behalf of respondents number
11 to 30.
11, 12, and 13. Respond then whatever date, 1st September. Yes, next. Yes. 1st September, Mr. Come ready with the compliance report. Both of you.
In serial number 34, my lord, I am for petitioner. I am for petitioner, my lord. Kindly have it on 26th, my lord. 26, we will conclude.
This is that request find this application for us. Petitioner is fine. Not it admitted. What is this PI? What is? Infructuous. Yes, madam.
No, my lord. No, my lord. No, my lord. It is not an infructuous, my lord. On Tuesday, we will.
Completed. What is this PIL? Yes, madam. What is this PI? What is this PIL about?
My lord,
you want the tender, right? Petitioner wants tender of the work.
Yes, my lord. For irrigation benefits, we have the government has not provided the irrigation benefit to the needy and poor people, my lord. Only the respondents number 6 to 11 highlighting that
tender. His work is complete, right?
My lord. My lord, kindly have it on Monday or Tuesday. Senior will argue the matter, my lord.
You are senior counsel. You are also senior counsel, madam. Interest. Notification. It counsel for the petitioner prays for adjournment to enable her to prepare the case and argue the same just after 2 weeks.
No, my lord, 26, my lord. Kindly have it on 26, my lord. Tuesday.
You may have a right to make a submission for adjournment. You cannot tell us what date to hear. Right? There is no urgency. That shows.
No, my lord, there is a these people
Otherwise, you would
are.
have, then please argue. We are ready to hear you today up to 6 o'clock. Argue. Go ahead. Argue. You can't have it like I will not argue today. I will argue only on Tuesday. This it will not work. Fine. Thank you. Yes.
35.
Yes, yes. Yes, madam. What I'm pleading, this is PIA. What is this PIL about, madam?
When they have identified that there are.
So they are the encroachers, right? Who are seeking their. That's it. No, are you an encroacher? No, he says no. So we will decide it in a writ petition, right? Who is an encroacher? Madam. You will be heard, we will hear you. I mean, whatever is your grievance. Alright, madam. After 1 week, learned counsel for the. Yes, yes. We are not doing anything. He is praying for adjournment. We are adjourning it to after 1. Which application? Nobody is interested, right? They are not appearing. You should be happy. Only one counsel is there. No. By next date you argue it out finally. We will not adjourn it. Today was a date dedicated to lakes, right? So we could not take up any other case. Lakes only, not parks. Park will next day, someday. Don't argue for the whole day. Yes. Park will counsel for impleading applicant praise for short accommodation list after 1 week. Then 36 no orders are required to be passed on IA2 of 22 as the petition is already listed for hearing. What is recalling, Mr.? What happened? Oh, dismissed. What the reasons suspending IA number 1 of 2022 order date 30th 2022 is recalled in the result. 24393 part 21 is restored to 5. IA is allowed. Yes, permission. What relevant document? Allowed a week's time to all relevant documents. What is the where is that order? No, there is no Mr. Order of which you are. Page 18 is the interim order. Interim. Wait for where is that petition? We'll have to look into the prayer clause, right? 35. What documents you are required to file? Let's see first. Pending disposal, may be pleased to direct not to approve the scheme of management. Ah.
The approved scheme of management was
We wanted to know what is the order passed on 10/6. What is it? 15/7. 15 July. 15 July 21. What is that order? 10/6/2022. You just now told us, right? We are having a look at this order. What is it? Well, the day means are you aware about 10/6/2022 order passed by this court? No problem. That's what we are asking. So what is this order? 15 July 21. July 21. What is it? Where is it? You have filed it, right? Where is it? Take chances like this, right? So be ready. Is the order which is passed? Is for adjournment to enable him to prepare the case in argument.
Petition 38. Yes. Having neglect permitted case with related Karate.
Chairman. Why? This is a public interest litigation, right? Why do you need 2 weeks? Not ready. Mr. Statement of objection filed. Okay, Mr. Yes. So, do you want? Whether he wants to file a statement of objection or we can go ahead. You have filed objections, right? He is praying for time. Learned counsel for petition prays for him. Each time
in this I appear for the some of the petitioners, my lord.
There is somebody is appearing before us and praying for adjournment.
Adjournment, my lord.
Hey, Mr. Amritesh,
yes.
See, there are 2 counsels. Just see, comment. So there are 2 counsels. You are appearing for some of the petitioner and one advocate is appearing for some of petitioner. You want to argue, he wants an adjournment. What should prevail? Prayer for adjournment should prevail, right? You will agree that prayer for adjournment should prevail. So it is at 40 minutes past 4, he's praying for it. So what to? So we'll take it up. Why? Oh, here's we lost the correction. For
May make
adjournment,
my submission. My name is not shown in the cause list, my lord.
we
That
will
is
direct
the
office is- all right, office is directed to reflect the name of Mr. Amritesh as counsel for petitioners.
counsel for petition number 18, 19 and 32, 34, my lord.
39.
Oh, so, Mr. You need not take the trouble of now. He's taken charge. He's senior to you. So we will hear him, Mr. Amritesh, on the next day. Don't this thing.
Next week, my lord, any day.
Ah.
Next week, any day, my lord.
1 week, Mr. Amritesh, after 1 week.
Yes, my lord. Much older. Much older.
Yes.
39. Kumar SP, Ajay Kumar.
Are the present Lorette Council corresponded raised for adjournment on the ground that arguing counsel is available list immediately after 1 week. Right? Yes. 20 July or 28 July 2020.
Party, CGR Mohan, government education.
Hey, Mr. Mohan, not your case today. No late. Yes. Yeah. Not another late. Oh. You should sail along with those writ petitioners. Huh?
Yes, sir, 7th good order. Government has not that has been taken on record.
Status report on behalf of respondent is taken on record list after 1 week. 1st August.
41. Prithvi Vadeyar, Sri Varun Jaikumar Patil, Abhinay Vaidya.
Next week. What possible, right? On account, mark the presence on account of paucity of time. The matter could not be taken up based on whatever date. Okay, next week, then first. So yes. Which date? 28 July. You are not in a hurry, right? The list on 1st of August 2022. Interim model. Yes.
42. Mukherjee, government education.
We hear two applications. What happened? You have filed a statement of objections. You are ready. Say so, Mr. Oh. Let us see. Let them. Who is putting up construction on road? Huh? He says that it's a road. You have purchased road, part of the national highway. By a city. Who has told you? No. What has happened? This notice has been issued, right? Mr. Patil. One respond. Yes, Mr. What? Also, please say so, Mr. We should not be in every case. We should not invite you to file. Say so, please. When will you? Right. Learned Additional Government Advocate as well as the learned respondent number 4 and 5. 5. Pray for short accommodation in order to enable them to seek instruction and to file statement of application if advice based on 29 July. Yes. 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 Oh, we continue tomorrow. Tomorrow. This tomorrow. It is on account of positive time, the matter could not be taken up. This tomorrow.
Continue tomorrow. ಎಲ್ಲ ಅದೇ ಬರುತ್ತೇನೆ ನಿನ್ನೆ ಇತ್ತಲ್ಲ
number 47, my lord. 47, my lord, for appellant, my lord.
No.
Serial number 44 is called, sir. Please wait.
I don't want you to argue the case today. Huh? Yes.
ಇದು ಯಾವುದು ಇದೆ ರೆಡ್ಡಿ
Yes. But on the question of admission, the appeal is admitted on following substantial question of law. Number B, substantial question of law B, page 70. Right? Issue notice.
I beg for the respondent.
Yes. Learned counsel for petitioner pays for appellant, pays for short accommodation. List after 1 week. Got it? Go. Petition. Tomorrow, day after. Yeah. Yeah. Mark the presence on account of paucity of time. The matter could not be taken up. Yeah. Yes.
Number 47.
For appellant case, my lord.
Yes.
Raise for 2 weeks time, my lord. Interim order, my lord.
No. That's the problem. You are in comfort zone because of interim order. And why should you not seek 4 weeks time? Why only 2 weeks?
No, my lord.
No, next year.
Sorry, my lord.
On account of paucity of time, the matter could not be taken. Just in the next week, interim order shall continue till then. Next week, Mr. Go.
48.
Yes, madam.
ಎಲ್ಲ ಕೂಡ್ತಾರೆ
Ah.
ಆಫ್ ಮಾಡಿ ಮಾತಾಡೋದ್ರಲ್ಲಿ ಕೇಳುತ್ತೆ
Heard on item number 2022, an application seeking dispensation from the requirement of filing the translated version of the documents for the reasons assigned in the application. The same allowed. IA 3 of 2022 is allowed. 3 of 22. Accordingly, IA 3 of 2022 is allowed. Counsel for the appellant pays for adjournment to enable the prepare the case in RBC. Just after 1 week, 2 weeks. 1 week. There is a stay. No stay. Refreshment. So we have discussed with the requirement Adam of filing. So after 2 weeks, right?
49. MC Basuraj. MC Basuraj.
On account of positive time matter. Short.
50.
Same order on the count of paucity of that did not be taken up. Please stop one. Yes. Representation will be all right. Yes, yes. Bobby Brothers. In this petition. The petitioner. Petitioner in the area seeks a pleading in the nature of mandamus directing respondents number 2 and 3 to conduct the survey of the land belonging to the petitioner bearing survey number 629 of the resolved fair clause. And to submit a report to and so. Paragraph. At the outset, submits that the petitioner has submitted a representation with regard to his grievance to Tehsildar Oka, to the Tehsildar Oka, and the petition be disposed of with the direction to the Tehsildar to decide the representation submitted by the petitioner by a speaking order. On the other hand, the additional government advocate fairly submits that suitable action on the opposite representation. Paragraph counsel for the parties and the facts of the case. Petition contained in the Register C dated 18/1/2022 by a speaking order within a period of 1 month from the date of receipt of copy of this order. It is made clear that this court has not expressed any opinion with regard to merits of the claim. According line below, accordingly, petition is disposed of. Huh? Rule 53, there is a remedy. Tomorrow? What? No. So, what he is pointing out, there is an alternative remedy of filing a revision. 53. Is it so? Of course, tomorrow. We are just asking you, is it there or not? You will say, you will see. Oh. Counsel for the petitioner prays for adjournment in order to enable him to make a statement whether the petitioner has any statutory alternative remedy against the endorsement dated 9/6/2022 issued by respondent number 2. When do you want? Next week? List in the next week. 9. What is it? Oh. Learned judicial comment advocate submits that with that order at the validity of section 10A of Mines and Minerals within bracket Development and Regulation Act. The Amendment Act or 10A of the Act. What is it? Amendment Act. Because Amendment Act will be different than section 10A. It can be that the 10A is brought about by additional government advocate submits delete none for the petitioner. Learned additional government advocate submits that the issue involved in this petition is very covered by 18th of June 2019, delivered by Division Bench of this Court in WP number 6447/2019. Awaiting appearance of counsel for the petitioner, hearing is deferred. Yes, next week. Continue. One minute. Yes, what about 66? Mr. Who appears? Mr. Mahendra, yes. Next week. Yes, next week. Why? 26th is auspicious. Have you found out? Yes, sir.
63, my lord.
Yes.
63, my lord.
1 minute. 57. Yes. It's from 28th July. Or is framing of charges, right? Frame for the petitioner. Yes. So yes,
63, my lord.
No, that's fine. But he's praying for adjournment 2 weeks. You make it tomorrow, right? All the other cases will come up tomorrow. We will have to remain present on the next date also. Next week, he tell us anyway. Which day? How are you? 29. All right. Mark the presence, learned counsel for respondent place for an accommodation list on 1 minute. Will not go away. We don't run away, right, from this situation. 29 July. Yes. Yes, madam. 53. He has filed a petition for dismissal. Room 14. So why? All right. So next week we will take it up, madam. Why should you? Why 2 weeks? On account of paucity of time, it could not be taken up. Yes, next week. Date? 28 July. 28 July.
63, my lord.
It will. No, it will appear tomorrow. We have heard. Hey, what will we will forget by that time, right? Everything about the case. So Mr. He is arguing counsel for respondent. You have concluded, right? Petitioners have concluded their submission. We will forget. You don't have to do. No. Please appreciate. I mean, you don't have to do anything. You have already argued. We are hearing Mr. Sabrat, right? Yes, please. Mr. Sabrat has to argue. Yes. What do you want? All cases are coming up tomorrow. Yes. We are hearing only those counsels who want an adjournment. You are not the one, right? Seeking adjournment. 50? 55? Why? What final? So you don't want to be disposed of, right? Right. Senior was, I had argued one matter before us last week only. Wait a moment, in the interim order. There is an interim order. Oh, you can argue next week, Mr. Not extended. No interim order. Here. Not extended. So there is no race for adjournment. 55. Mark the results. Learned counsel for petitioner. Why do you pray for adjournment? There's no. Why do you pray? Well, so learned counsel for petitioner submits that the arguing counsel is unwell and is hospitalized. So, discharge. Not treated.
Till disposal, it is there.
Hey, Mr. This all don't make incorrect factual statements. We rely on you, right? Still, we have never made a incorrect statement before the court, and that's why we tend to rely. This interim order is during the pendency of the petition. That's why. Don't say that it was not extended. Please see, Mr. Youngman. Please see. Don't make an incorrect statement. Don't, I mean, otherwise, if you don't know, no, please see this one. Say, why should you make an incorrect statement? Don't say like this. Not fair, Mr. That's why. Not fair. July. 56 also 28 July. Any other why? Saturday, right? 30th is ideal. Here July 10:30. We'll vacate the interim order. What is there? You'll find immediately. The moment we modify the interim order, immediately next day you will 10:30. You will come up with a mention memo. You will have the whole this thing, entire time. It is not fair. 29th July. Fine. That's it. Hey, don't. Tomorrow it will come up, right? Why? Yes, for 60 item. There's nobody listed. You can make a mention.